So, good afternoon. I'm just putting on my camera again. Okay, great. So, this. Welcome to this first session of Module 10 on EU competition law and intellectual property. For the Module 10 on IP, we have the honor to welcome Esther van Zimmeren, who is Associate Professor in Intellectual Property, Law and Governance at the Faculty of Law of the University of Antwerp in Belgium, and a member of the researcher group Government and Law and Business Law. Esther, please correct me if I make any mistakes. We will have later on this afternoon Miguel Rato joining us. He is a partner at Queen Emmanuel, where his practice focuses on EU competition law. He advises clients on a wide array of contentious and non-contentious EU competition law issues, with a particular focus on unilateral conduct matters, transaction, and IP licensing in high-tech industries. So you are invited to come to the lecture next week. So please let us know in advance if you're coming. The slide has been uploaded on the BSC account, but let me know if you have any issue with that. And it's good to see you. So open your video. Do not hesitate to raise questions with regards to IP law to Miguel or Esther. And thank you again for being with us today, Esther. The floor is yours. Thank you very much.
Thank you for your kind introduction. My connection is not always good. I think it's due to the weather that we have at present in Belgium.
Yeah. Do you want me to share my screen, maybe?
But so tell me if there's problems, if you have problems hearing me.
Sure.
And I will, for now, I keep my video on, but when I'm sharing my screen, I will keep I will put the video off just to be sure that we're not overusing the connection. Yeah. And before we really start going into the content, I always like to make a brief round of introduction also on your side, so that I know who's participating in this session. So Valerie will also send me the full list, but it's always nice to hear a little bit whether people already have prior knowledge or prior experience in intellectual property law. That helps me to also connect to your frame of reference, so that I'm not giving a very, very basic introduction if everybody already knows all of that. So I know that, of course, this module is part of a more general module of the LLM in competition law. So you're here especially for competition law. But this module focuses on the interface with intellectual property law. And so my first part of the introduction will focus on that, on IP law, on innovation, more general issues of innovation, and the role that intellectual property law and other instruments are playing in that context. And then Miguel Rato will follow up already much more on the interface, the actual legal interface, the legal framework in EU competition law that deals with that interface on IP and competition law. But so we think it's important that you have at least a general awareness of the differences between the different intellectual property rights, even though most of the actual cases focus on patents, know-how, and maybe a little bit on copyright for software. But we still think it's relevant to give you a brief overview of all the intellectual property rights. So before I start doing that, as I said, I would like to ask you to do a brief round of introduction, and maybe we just go over the list. I have here the list of participants. And if we follow the alphabetical order, then Aga would be the first person on my list. Would you like to introduce yourself and tell us what is your the organization that you're working for, and whether in your current work or maybe previous experiences you have dealt with intellectual property law, or if you have maybe studied IP law in the past, so that I have a little bit of an idea of that. It can be brief, just to give me some idea of your prior knowledge. Okay. Okay, brief study of IP law in the past. Okay, no problem. I hope that you can hear me well. So next person would be Aya Larsen. Can you try to see whether your microphone is working?
Yeah, can you hear me?
Yes, excellent.
Yeah, I'm a lawyer at a medium-sized Danish law firm. I have some experience with IP, mainly trademarks, and I also took some classes at university as well.
Yeah, that's good to know. So already two people with some background in IP law. Andrea, you would be the next person in line.
Good afternoon. My name is Andrea Pedrera. I'm from Ecuador. I'm working in the competition agency of Ecuador, and I don't have experience in intellectual property.
And did you study IP law a little bit, or you don't have any basic knowledge of IP law?
No, I don't have.
Okay, no problem. I will just start with a brief introduction. No problem at all. Thank you for explaining that to us, and welcome in the module. Let's go to Beatrice.
Hi, I'm Beatrice. I'm a Brazilian lawyer. I'm currently living in Lisbon, Portugal. I have my own law firm, and it's a small consultancy focused in antitrust, and my background is in antitrust in Brazil. And I don't have any experience in intellectual property, so it will be my first experience.
Thank you for that. It's nice to see that we have a very nice and diverse group coming from different jurisdictions. So maybe I can also learn a little bit from you through your questions and comments later on during the 3 classes. So very welcome, Beatrice, too. So Charlotte.
That's me. I'm a German qualified lawyer. I'm working in a mid-sized law firm as well, and I'm mainly working in IP, so I'm quite familiar with IP topics.
Good that I know. So I will ask you the tricky questions, Charlotte. So let's go to Daniel.
Hello, everyone. My name is Daniel Granja. I'm from Ecuador as well. I also work in the competition authority here in my country, and I also don't have any experience on IP.
Okay, Daniel, there was a little bit of a twitch in the signal. So if I could hear you well, you mentioned that you, oh, okay, there's a problem on my side, apparently.
If you want me to repeat anything? Oh.
Yeah, please do so. I will just put off my camera for a bit, but I'm still here and I can hear you very well.
Okay, I'm going to repeat my introduction. My name is Daniel. I'm also from Ecuador. I also work here in the competition authority in my country, but I don't have any experience on IP.
Okay, thank you for that, Danielle. It's very nice that we have a nice mix of competition authorities and people working for law firms. That always gives a good opportunity for discussions and different perspectives. So the next person is Fabian. Fabian Zierman. Maybe there's also has difficulties with the sound. Fabian, if you want, you can also send briefly an introduction by chat, just like Aga did before. And otherwise, we can maybe come back to you later on. Yola, can you also briefly introduce yourself?
Hello, everyone. I'm Yola. I'm from Albania, and I work in the law study in my country. This would be my first experience in intellectual property.
Okay, thank you, and welcome, Yola. So then the next person is Judith Brulmeijer.
Hi, Judith. I'm a compliance officer in the Compliance Investigations Department of ThyssenKrupp in Germany. And yeah, also for me, it's the first time intellectual property law. So I'm really curious about what we're going to learn from you.
I'm happy that you're curious. I hope more people are curious because it's actually one of the nicest fields in the law in my to my taste.
Okay.
So it's yeah, it's of course a lot about creativity, but also in many different sectors. So so that is really fascinating. And so in the last class, so the second class, it will be very much on the substance of the law. The interface between IP and competition law on Article 101, 102, important abuse of dominance cases. But the last part will also focus specifically on two sectors, especially also standardization, which is the area where Miguel is working day and night, I assume. So the standard essential patents. So if you read a little bit on the interface between IP and competition law, that's a key topic. And then I will focus a little bit more on the pharma sector, where of course also innovation and intellectual property rights are very important. I see that a lot of screens are being blocked, so I hope you can still hear me.
Yes, we hear you.
Okay, that's good. So it's just that the screens are a little bit blocked, but good that you can still hear me. So let's go to, yeah, thank you, Till, for putting up a thumb. I will ask for confirmation probably a few more times during this session because the weather is really, really bad here. So I think that's probably one of the reasons why we have this. So next person would be Julian.
Yes, good afternoon. I'm Julian. I work for the Belgian Competition Authority, but I don't really have any experience on the IP law so far.
Mm-hmm. Very good. And you have a legal background or an economic background?
Both. I studied economics first, and afterwards I studied law.
Ah, wow, wonderful. Yeah, that's the kind of people that we need at the Belgian Competition Authority. So welcome also to this module.
Thank you.
And I hope that I will be able to come also next week for the physical class and that I will also be able to meet with some of you who are actually in Belgium. So next person is Katarina.
Hi, everyone. My name is Katarina, or short Kati. I'm not an economist, just a lawyer, German-based, and I recently became an in-house counsel for antitrust litigation at Daimler Truck. So in my current job, I do not have much to do with IP-related topics, but in my previous job, I used to be more generalist, competition counsel at Mahle GmbH. And there, to be honest, I had limited experience with IP law, mostly interfacing the R&D block exemption. And I was always really happy when I could turn to more experienced colleagues in this field, because to be honest, to me, it was always very complex. And so today I'm really looking forward to this module and for you to enlighten me a little bit.
Well, that's yeah, we will try as much as possible, but I can very well understand that indeed working with the block exemption was not easy, because already some of the basic things in competition law, such as defining the relevant market, is very difficult when you think about innovation. So already with those very basic concepts, that's where the trouble starts. Where for other, let's say, more stable areas, this is often slightly easier. But so yeah, I hope we can match your expectations in that respect. Very welcome. And it's not bad if you don't have an economic background. I also, I'm just a lawyer like you, so. But in competition law, it's really very, very helpful, of course, if you have also an economic background. So So that's why I noted that. So let's go to Kyriakos. Please go ahead.
Hello, my name is Kyriakos. I'm from Greece. I work for Avgitidis and Partners law firm, a boutique law firm based in Athens, and I have studied intellectual property in my last LLM, the LLM I attended previously, in the University of Athens. Thank you very much.
Oh, that's very nice. Yeah, I'm nodding the whole time, but you don't see that. So sorry about that. So really nice that you already had that in your LLM. Did you have several courses on IP law or just one more general introduction course?
Actually, it was one subject for in IP law.
Okay.
Yes, that was the way I studied it in the first LLM.
Yeah. Okay, very good. Yeah, sometimes you have LLMs that really focus on, for instance, this interface between IP and competition law. For instance, also in Liège, there's a program where that's happening. For those who could be interested, who are so excited about the interface that they want to learn more. So thank you for that, Kyriakos. Salah, would you also like to introduce yourself?
Yes, hi. I am Salah from Egypt. I'm working as a manager, contract manager in a company operates shopping malls and luxury brands and also stuff. Regarding the IP rights, actually, I remember that I have general knowledge before while studying in the bachelor, but not very not very good. Like I don't remember. I think actually currently, and I'm not using this not using IP rights in my work mainly. Can you hear me?
Yeah, I can hear you well. Yeah, again, I'm nodding. I can imagine that probably in your business, IP rights are very important, also trademarks especially. Yeah, of course, not in all activities that will be so important in your day-to-day practice, I can imagine. So very welcome, Salah, and I will try to revive the knowledge that you already had acquired earlier.
Thank you.
Okay, the next person in line would be Sonia.
Hi, sorry, just unmuting my mic. I'm an Australian qualified lawyer and also economist. It's quite usual in Australia for you to do a combined degree. And I've got lots of non-EU competition law experience. And I was just thinking then, one of the first cases I worked on in Australia was a patent and competition law matter, but I can't really remember it so long ago much of the details. I've mainly worked in telco and media, and so I haven't come across the interface between IP and competition law, but I just know that it's quite complex. So I'm looking forward to the lecture series on it.
Yeah, I can imagine that, especially then also the lectures of Miguel will be very, very interesting for you also on the standard essential patents and how that whole case law has developed over time. It's quite tricky, but I think he does a good job in explaining it. So I think that will be really interesting for you. But hopefully also the pharma part, but then out of general interest maybe. Okay, great to have you on board too, Sonia. Welcome. Then next person would be Simon.
Hello, can you hear me?
Yes, indeed.
Okay, good afternoon, everyone. My name is Szymon Gołębiowski. I'm qualified and practicing in Poland, in Warsaw. Currently, I'm working for Berkenberg, which is, I would say, an international law firm with strong IP background. And during my entire career, I worked a lot. I used to work a lot with IP lawyers and life sciences lawyers. I think that IP and life sciences, these are two expertise which have a lot of in common with each other. My main area of expertise is competition law. but I have worked a lot with my IP and life sciences colleagues.
Okay, that's very interesting. And would that be in on EU law cases, or also more specifically in Poland?
Yeah, this was in my opinion, these are areas of law which are strongly harmonized at the European level. So even if these were national laws, we usually had to consult the EU legislation as well.
Yeah, the reason that I'm asking is that also I know in several countries that there's some interesting specific cases, but I wouldn't know for Poland. So I was just curious to get some more insights on that from you. So I'm using the opportunity of giving this class to also learn about what's happening in your respective countries. And I will also try, for instance, in the lecture, the pharma lecture that I will give in the third part, to speak a little bit about national cases too. For instance, if you think about excessive pricing in the pharma sector, there is basically only one relevant case at the EU level, the Aspen case, but there's a lot going on at the national level, and the national competition authorities seem to be much more some of them more courageous in applying excessive pricing principles. And so that is quite interesting. So if you would have anything to add during that lecture or other lectures, and that applies to all of you, if you have interesting insights from your own jurisdiction, that's always interesting to share, because Miguel and I will not have a complete overview. And so in that way, we are really complementing each other and learning from each other within the whole group. Okay, wonderful, Simon, that you are also on board. So the next person is Till Fischer.
Yeah, good afternoon. My name is Till. I work in the antitrust team at Dentons in Frankfurt. I have some theoretical knowledge about German design, trademark and patent law, but I would say what is left from that is pretty much limited to any behavior that would fall directly under 102 TFEU. So I would be happy if you could maybe bring back some dark memories during the day. Thank you.
I will try to do that. So a little bit like for Salah, revive old knowledge, which will certainly still be there. So our next person in line is Van Nguyen. Please go ahead.
Hi everyone, I'm Van. I'm German based and I work for a international law firm called McDermott. And actually I don't have any experience in IP law, so I'm very excited for the upcoming sessions.
Okay, very welcome, Van. I'm happy that you're here too. And so, yeah, we have a very diverse group with some basic knowledge, some more expert knowledge. So I hope it will not be boring for those who have already some more advanced expert knowledge, but then you will get lots of new things to hear from Miguel, I'm sure. And maybe a little bit also more on the innovation side from me. So Vivian, go ahead.
Hello, I'm Vivian. I come from China, so good afternoon and good evening, because it's almost 8 o'clock in the evening. I am a lawyer. I practice since 2007, but I haven't dealt with any IP law issues. So I'm very excited to take the course because I chose a very topical issue as my dissertation, because SEP from cases is more and more important in PRC. So I would like to pick this topic, but I found it's a very difficult topic to draft. So I'm very excited to take the course to help me for the dissertation. Thank you.
Yeah, so we're very happy that you're joining, and so very courageous indeed to do this from China. Sonia, are you actually also in Australia or you're located in Europe?
I'm located in Europe. I'm also Italian. I'm in Milan. So I consult with a couple of firms here, and I do sort of the English side of competition law here.
Yeah. But so you don't have the challenges with the time difference, which Vivian is having.
So often in business, which is great.
So very nice, Vivian, that despite that time difference, you're also on board. So let's go to Wiebke.
Yes, hi, my name is Wiebke, pleased to meet you. I'm based in Germany, working for an international group of companies as in-house legal counsel. And even though I've been doing that for quite some time, I wouldn't consider myself to have any experience with IP topics, unfortunately. Always trying to get that off my desk as fast as possible. So sorry, my batteries are
so
low.
I hope that we can
heard me.
Fill that in. We can fill that in. Of course, it's only a limited number of hours, and you could have a whole program just on IP and competition law. But at least I think all of you will get some awareness of the differences and some of the challenges. Let me see. I think the last person would be Yves.
Yes, hello. My name is Yves. I'm a Swiss certified attorney at law. Currently working in a smaller law firm, but I have previously worked in the competition law team of a major firm, and to very limited extent I have experience in IP law, but I'm looking forward to, in particular, the interface between competition law and IP law.
Okay. Thank you for that. So I think there was somewhere along the line, there was Julian who did not yet give an introduction. I don't know, Julian yeah, it was Julian, no, we missed.
No, I think I
there?
already gave it the introduction.
Okay, but there was somebody with a J, I think.
I think it was Fabian.
Fabian.
That is perfect timing. Sorry, I just got off a call. I'm writing a PhD on competition and IP law in the esports and gaming sector. So IP law is very relevant for me, but mainly the copyright parts, obviously.
Okay. Yeah, so then unfortunately for you, we'll spend a little bit less time on the copyright side. But if you would have additional questions about that, you can also always address me or Miguel with specific questions. Most of the cases that we discuss deal more with patent law, maybe a little bit on copyright law, but especially in terms of the essential facilities doctrine. I'm not sure whether that's such an interesting part for you, but we'll see. You can always ask questions. So Fabian, and sorry, Julian, that I mixed up Julian and Fabian, a little bit similar, the names at least. So welcome to all. So this was our first easy introduction for me. I tried to put back on my camera because I had the impression that the weather was a little bit better. But when I'm showing my presentation, I think I will again, as said before, put off my camera just to be sure that it's not too much for the connection. So when I share the screen, of course, I can see some of you still. So I would prefer if you keep on your camera, if that's okay for your own connection, because then I have the feeling I connect a little bit with you and I see reactions. If things are unclear, if I see puzzled faces, I know that I need to elaborate a little bit more. So if everybody puts off the camera, it becomes so impersonal. So even though I will do it myself, I hope that many of you will keep it on and that I can see, whether things are working or not in terms of my explanation. And so we will start with 1 hour of introduction from me, then we will have a short break. Then I will continue, I think, what did I say, for another half an hour. And then Miguel will join around 4. So that's basically the plan for today, but it depends a little bit. If you have many questions, maybe the time frame will be a little bit different. We'll see how that goes. So sharing the screen. Always exciting to see whether it works. So I'm sharing it now. Can you already see it? Not yet.
Yes.
Yes, I see Eve nodding and Till with the thumbs up. Okay, thank you for that. So yeah, so maybe let's see. So Valerie already introduced me. You already also introduced all of you. So just one additional note to that. So my specialization is in intellectual property law, but I have a special interest in the interface with competition law. And so also my PhD was on the changing paradigm, especially in the biomedical sector, and the way that people are dealing with patents in that sector. That's already a while ago now, but I'm still interested in this, even though I'm not writing that much on the topic. I'm following all the developments and sometimes writing a little bit more about that, again, mostly in pharma biotech sector. But so I'm affiliated with two research groups at the University of Antwerp, which is government and law and business and law. And that shows a little bit the ambiguity of my interest, and also explains to you probably how I will address IP law. So I don't only focus on more substantive law issues, but also more the governance. How is the IP system operating? If the patent office is granting patents, what is the context to that? How is it functioning? And then not only the public governance, but also more the private governance of that. So also the economic context, the policy context of that, and how are the EU institutions, how are they collaborating, or how are they not so well collaborating? You will probably also hear that from my critical comments, especially also about the interface between, for instance, IP granting authorities and the Commission, and that there's so much expertise which they are only just starting to share, which I think is really a missed opportunity and could be done much more, because these two fields as such are already so complicated. And then sometimes when the Commission is dealing with IP cases, it shows that it would be good to get some further detailed knowledge of the IP granting authorities, such as the European Patent Office for Europe. So what will we discuss today? So here, as I said before, first some context on innovation policy, and I also emphasize how intellectual property rights are just a very small piece of the puzzle in terms of encouraging innovation. There are many other instruments that are being used and that are also relevant. So for those of you who may have worked in the past or are still working a little bit also on tax law issues, so in many countries, there are things like patent boxes, which basically are a tool for governments to attract companies that are very innovative, that engage in a lot of R&D activities, to attract them to the country, or to at least to attract the R&D activities through special tax arrangements. And this is something where also the OECD has been quite active. And you can probably very well imagine that in terms of the business strategy, those kind of other instruments or funding instruments are also an important interface with the interface of IP and competition law. So this is why I want to stress that, even though probably typically if somebody else would be giving this class, they may not have emphasized that element so much. But I think it's very important because it gives you the bigger picture. Then I will also describe the variety of intellectual property rights and the different characteristics. What is the subject matter that you can protect through copyright, through trademarks, through patents? Are there exceptions to that, particular types of inventions that you will not be able to get protection for? I will also give some brief information in terms of where you can get protection, but again, focus primarily on Europe, even though I realize that many of you are not from Europe, but may still have an interest in also how IP rights are granted in Europe. as we're doing this program from Belgium, I also mentioned the Benelux, even again, that may not be relevant for all of you, but in IP law, there's harmonization at many different levels. There's, of course, international treaties, such as the TRIPS Agreement, the Berne Convention for copyright, the Paris Convention for different industrial property rights, a lot of European harmonization too. There's different directives in terms of copyright law. In patent law, we're getting started. Maybe some of you have heard of the unitary patent and what that may bring in the future. So I will just briefly touch upon all those issues so that you have an awareness. And so what is the reason that I mentioned Benelux is that, for instance, for trademarks and designs within Belgium, Luxembourg, and the Netherlands, you wouldn't apply at the national level, but you would apply at the level of the Benelux. These countries are working together, of course, super small jurisdictions, so it makes sense to collaborate. And so that's what has been happening in the area of trademarks and designs, but not so much for the others. Then I will say something also about the optimal design of intellectual property rights. So that's more of a kind of critical perspective and a little bit on IP strategy. So starting more with the innovative context. So a reason or a justification for having a whole module on the interface between IP and competition law, you can derive that from this slide where you see the increased importance of intangible assets in comparison to tangible assets. So whereas in the 70s and 80s, it was still primarily the factories, the machines, which made up the value of a lot of companies worldwide. But over the last decades, this has been changing. So there has been a big shift towards the importance of intangible assets. And intangible assets is, of course, not just IP rights, but IP rights are an important part of the story. There's also know-how. Some people consider know-how and trade secrets also as IP rights, but there's some, among academics, there's some discussion whether know-how is really IP, but that's more of a theoretical discussion, but very important part of the intangible assets. And of course, also people, humans, employees are part of that kind of intangible knowledge. And that applies to many sectors, but certain sectors in particular. So if you think, for instance, of the pharma sector, I already mentioned a few times. So the pharma sector is really one of the few sectors which is heavily dependent on intellectual property rights, and where also there are special extensions created, which are, for instance, called supplementary protection certificates, SPCs, which allow or which give possibilities to go beyond the normal 20 years protection that you have for patents. So in particular circumstances, you can get an extension through those SPCs. And in addition to that, you also have data exclusivity, market exclusivity. And so the pharma sector, biotech sector, they would very much emphasize the importance of those rights and exclusivities as important incentives, because the investments in innovation and R&D are so significant in this area that they say we really need those rights, because otherwise, especially with the more, let's say, simple synthetic drugs, they're so easy to make, so that once a product is on the market, competitors will quite easily make the same products. And this is why those IP rights, especially patents, but also know-how, and also the exclusivities, data and market exclusivity are considered so important. More important than in certain other sectors. At the other side of the spectrum is often, for instance, software, but there's a lot in between where IP rights are important, but maybe not as important as they are thought of in the area of the pharma sector. And there's a lot of discussion in terms of prices all around the world. So of course, there's a big pressure on many health budgets in many countries. And so there's a lot of discussion on prices that would be too high. And you see, so the question then is that then a task also for competition authorities to step in? Or is this a task for the health regulator or for ministries that actually sets the prices together with companies? So this is also, from my perspective, from a governance perspective, as I mentioned before, a very important question, because competition authorities are getting more and more tasks. Also, if you think about recent developments such as the DMA Act in Europe, the more in the digital context, you see that competition authorities are getting more and more tasks, not always easy tasks, especially if you think about the expertise that is needed in the area of IP law. And so discussions about prices and what is maybe a price which should be considered anti-competitive, that is not an easy discussion. And making the economic analysis too, having access to the data is quite problematic and complex. And so you see that many competition authorities are struggling with this. They see that there's an issue, that there's a problem, but the question is it their task? And if so, how to do this? And there's also a lot of academic research on this. So if you're interested in this topic, just let me know and I can give you some further information. I will touch upon that, of course, also in the final class, which is more about the pharma sector. Of course, also within the context of COVID and access to drugs, there is
Yes, she's done. I'm really sorry for this. Yes, we are having a storm in Belgium. It's bad. Just we'll wait that she's joining back. 5 minutes maximum. Apologies. Okay. Okay.
Okay, I'm back.
Do you want me to share my screen still, or will it be fine? What do you prefer?
Yeah, so I don't know what it was. The thunderstorm is over. So I will just continue where I was happily, and let's hope that we will not get disconnected again.
It's fine.
Yeah, if I'm away, I will very soon get back. So don't give up on me. But I will put off the video and share the screen again. Stop video. Can you see my screen? Yes. Okay. So I was talking about the waiver of the TRIPS agreement related to COVID vaccines, treatments, diagnostic tools. And so they're still discussing this at the level of the WTO. And I think it is still relevant for access in developing countries and for future vaccines. We don't know what we're heading into in fall. Now it seems to be relatively stable in a lot of countries, but we don't know where we're heading. So this remains relevant, but I will not go too much into that, but just as a reminder that is also very important for this, this interface. There's also, of course, competitive aspects to that whole discussion too, whether all intellectual property rights of the relevant manufacturing companies, whether they should be waived or not. That will have a huge impact, not just in this context, because it hasn't happened before. So if this step is taken, that may have a much more global impact in terms of how companies look at intellectual property rights, especially in the pharma sector, but perhaps also beyond. So I'm not saying that I'm against thinking about this waiver, but sometimes it's mentioned too easily, perhaps, as the solution for the problems that we're seeing there. Then you now see a slide normally related to Internet of Things. So Miguel will talk quite a bit about standard essential patents, standardization. A lot of the cases in that area until now still relates to relatively easy technology. But as we're moving towards Internet of Things, where interoperability, connectivity, compatibility is even more important, where also the number of patents that people will need access to, that different companies will need access to will be higher and higher. So fragmentation in that area will become more and more problematic. So this whole issue of standardization and standard essential patents, I would expect it only not to go away, but only become more and more important in the coming years when more and more people start using these kind of smart technologies that are integrated in the Internet of Things. So again, to emphasize and to justify to you why we have decided to focus in this course specifically on pharma and on standard essential patents. It's not just because it's important now, but also because we think it will be important the coming years as well. Then also still in terms of context and the importance of innovation, what you also see, especially the last decades, but also before to a lesser extent, is more and more collaboration in many different sectors. So sometimes that is referred to as open innovation or co-creation. So where you see that companies realize that there's so much knowledge around them that they don't have all the know-how inside, and that it's really necessary to collaborate with other companies, with universities, with competitors as well, small and medium-sized enterprises. And so in order to safeguard their intellectual property rights, open doesn't mean no IP rights. That's what a lot of people think. The same also with open source. A lot of people think that open source or open access means there are no intellectual property rights. So that's not true. Also, open access, open source, they're based on copyright protection. But the IP owner, the copyright owner, decides to open it up and to make it available to a broader public. And so that's the same with open innovation. Open innovation doesn't mean that IP rights cannot be protected. or that you're sharing them with whoever wants it. But it just means you need to think much more strategically with whom you want to share and how you will do that. And so there are licensing agreements and R&D collaborations with very well drafted clauses related to the transfer of IP rights, very well defined, very specific, have only become more important within the context of open innovation. And this is where I think it was Kathy who mentioned this, that working on the technology transfer block exemption regulation, dealing with that, looking at different types of clauses, as those clauses are used in all those different types of agreements. A good understanding of that is really important also within the context of open innovation. So if you are taking something from this slide, then I hope the take will be open doesn't mean no IP. Open means IP, but thinking very strategically about what you do with your intellectual property rights and the conditions under which you would be licensing out, you would be collaborating and transferring, sharing your, what is often referred to as background IP and foreground IP. So having very advanced provisions in that. And so that means that also small companies need to be quite need to have a good support by lawyers who have at least a certain awareness of the relevance of the TTBR and the type of clauses that are relevant there. And so next week, we will also look together at some relatively basic licenses for those of you who haven't seen any IP licenses before, and we will just look at different licensing clauses that actually deal with the transfer. In this way, I hope to give you at least a basic understanding of the clauses that can be relevant in that respect, that can be relevant also for if you're checking compliance with the TTBR. Okay, let's move to the next slide. So often people use the term innovation in a rather generic manner. And of course, we have at least one economist. Now, Sonia also mentioned she also has an economic degree. So I'm sure you will not use it in a generic manner, but a lot of people do it. And it's important to think a little in a slightly more advanced manner about this. And of course, I only have 1 or 2 slides on this, so I'm not that advanced either in my thinking, but just also to ensure that you realize that there's different types of innovation. And the most ambitious or the biggest changes in terms of performance is, of course, a more radical type of innovation, but that's relatively rare and it requires a lot of new knowledge and resources. And a lot of the innovation is more incremental, but can still be very, very relevant in terms of even being or amounting to the lifeblood of innovation for some companies. And so small changes in performance may have big differences. So if, again, I can use a relatively simple example from the pharma sector. So imagine you have a particular medicine. The medicine has patent protection. And then the same company, so the patent owner, further develops this and finds out that there's a better dosage regime, which is much more patient-friendly. So maybe there are less side effects, maybe it's less burdensome. So that can be very, very valuable for the patient. And so a very important improvement in practice. But still, by competition authorities and also certain other authorities or also health regulators, sometimes this is regarded more as an incremental innovation. So this is why we need to think quite in a more nuanced way about even those type of incremental innovations and not be too critical, because the economic value, for instance, in the pharma sector, is a quite complicated concept. Do you look also at the value for patients or not? And this is also something which complicates, for instance, the cases on excessive pricing, because there also the economic value is what you're looking at, and it's being debated whether that is including also patient value or not, and whether that should be taken into consideration. So you have all kinds of, you have lots and lots of economic papers, of course, on this that go beyond what I'm explaining now. But just to show you those different varieties of thinking about innovation, also, what are you innovating? Is it more of a technological innovation or a service innovation? Especially in particular sectors, this is very closely connected. Is this an innovation in terms of the technology, the software itself? Is it an innovation more in terms of the process and how it's being implemented in your business strategy? That can all be very valuable, but it includes different considerations in terms of the innovation. So here again, a slide where that is again emphasized, and where I also add social innovation, public sector innovation, which are of course not so relevant from a competition law perspective, but still are part of the whole innovation discourse. Okay, so I already mentioned in my introduction that I want to show to you that IP rights are part of a bigger toolbox that is meant to encourage innovation and also to attract companies to a particular country. So here I already mentioned tax as an example. So you have regulatory instruments, financial instruments, institutional instruments. So in terms of regulatory instruments, also things like tariff barriers, mobility, openness of science may play a role. Financial instruments, tax incentives, public funding, not only available for universities and research institutes, but also for companies, of course, also at the EU level. There's a lot of funding available also for companies. And that may come with certain strings attached in particular cases. Then also, is there good support? Is there a good venture capital investors environment? Is this supported? Is it stimulated? Is there a good framework for startups in a particular country? Also collaborations, things like technology parks, that's very advanced in some countries, but much less advanced in others. So you may have a very well-developed IP system. If those other things, if those other instruments are less developed, that may still lead to a very different innovation environment and R&D environment. So I think it's very important to take an integrated approach to that, even when you're looking also at this from a competition law perspective. And so also things like more ecosystem thinking and the open innovation and co-creation that I referred to before, again, makes it harder to think about specific concepts that are so common in competition law, such as the definition of markets. And also, especially how companies are linked to each other. All of that is pretty complicated, especially in very innovative environments, where also depending on the stage where you're at, is it a very new sector, very new technology markets? There will be a lot of different considerations that need to be taken into account also by competition authorities. Okay, we move. Yeah, go ahead.
I'm sorry for interrupting, but I just want to let you know that we may be having a little problem with the presentation because the slides are not changing.
Oh, that's interesting. I'm now at slide 15. At which slide are you?
No, we are just looking at slide 7.
Okay, but I think Valerie has shared a PDF version through the system. So what I would suggest is that you all upload or download, actually, Valerie uploaded it. If you download that PDF, and I will mention them the number of the slide where I'm at, so you can look at the PDF. I will try to share it again. So I will stop sharing and then share again, and we see whether it improves. But otherwise, you at least can already see, and you can follow through the PDF. Did everybody find the PDF? Any?
I will put it in the chat.
Yeah, I see Till again. Yeah, happily mentioning that he has a PDF. But I will, so that we don't lose too much time. But I will try to share again. Maybe it's better than, yeah, I see now too, when I try to open it, that the presentation is still, this is so weird that it's still on the old one. Do you now see number 15?
Yes.
Okay, what I can also do is not use the presentation modes. That also sometimes helps. And it's not really a problem if you can already see the slides because you have the PDF anyway. Okay, I will do it like this. And you can choose whether you look at the PDF and make notes to the PDF or look at the screen that I'm sharing. So I think I've already given you a lot of examples and ideas and the context. So now we will delve for another half an hour more deeply into the different intellectual property rights and different criteria and sort of the underlying rationale of intellectual property rights. Because what is important is that intellectual property rights are an exception to the basic principles of free competition. And you can imagine that, especially for the interface with intellectual property rights, that is an important starting point. So the idea is that if everything would be ideal, then free competition would be to very high level of welfare for society, consumer welfare. But the problem is that things are not ideal. And when certain actors or companies, inventors are coming up with new innovation or new types of materials that are quite easy to copy, that are quite easy to make, that other companies and competitors will use that freedom to copy or will use the freedom to compete and would start making the same product because consumers or people actually using those materials to produce particular products, they would want to have the same material. They want to have the improved material. So the idea is that if there would be no intellectual property rights, that people will benefit from the freedom to copy, and that the actual innovators, those who invest heavily in research and development to come up with those improvements, to come up with those inventions, or who actually have developed the know-how or the copyright protected software, they will not benefit from their improvements. And if you cannot benefit from your innovation and from your investments, you will not do it. If others can just walk away with it, if others can simply free ride on those investments and the research and development done by you, you will not do it anymore. And so the idea is that granting intellectual property rights to those innovators, to those companies, is justified. So, whoa, where am I going now? Yeah, so intellectual property rights are exceptions to that basic principle of free competition. And as most of you have a legal background, you know, exceptions always need to be interpreted narrowly. So also intellectual property rights, they are no absolute rights. And this is sometimes how some people perceive intellectual property rights. They perceive them as a kind of automatic monopoly. This is also created by the fact that some people call intellectual property rights monopoly rights, which is not very helpful. So this is why I prefer to use the term exclusive rights, because intellectual property rights allow the IP owner to exclude others from simply making the same products, for which there is IP protection. And so the term exclusive rights much better emphasizes that this is a kind of negative right. You can prevent others from doing certain things unless they have your authorization, unless you have licensed them to do so. But you will only have those rights, those exclusive rights, for a particular period and for a particular territory, because intellectual property rights are also territorial rights. And so if you are a multinational company and you want to protect your invention internationally, there is no such thing as an international patent. There are international treaties, but those treaties are especially meant to harmonize the substantive requirements or procedural requirements, or to actually make it easier to get protection. but an international patent does not exist. We do have a European patent, so that is for at least a relatively high number of European countries. There is a collaboration and you can apply at the European level for protection. But if you want to get protection also in China, in the Philippines, in the US, in Australia, you would need to apply for protection in all those countries. And to a large extent, the criteria of novelty, inventive step, they are harmonized through those international treaties, but the way they are interpreted by courts may be different. So this is quite challenging. These territorial rights are quite challenging in that respect. So these limitations and the fact that intellectual property rights are exceptions with a limited term of protection and a limited territorial protection, that creates challenges and also leads sometimes to different decisions by courts in different jurisdictions. So you have many cases also in the area of telecommunications where possibly a particular patent from the same patent family related to exactly the same invention might be considered invalid in, for instance, the US, and valid in and infringed by in a dispute between the same parties in Europe or in any other jurisdiction for that matter. So really important, this territorial nature creates quite some challenges. There are also certain exclusions. In many jurisdictions, there are particular inventions for which you cannot get patent protection. And for all the countries that are not a member of the WTO, or before the TRIPS agreement, there were a lot of countries that didn't have patents in the pharma sector, actually because they wanted to ensure access to medicines. But the TRIPS agreement changed that. And so all WTO members, even though there are some special transition periods for particular countries, but all countries that are not in such a transition regime need to have patent protection for pharma products, even though they might not have had that before the TRIPS agreement actually entered into force. So that's another basically limitation of this, of what you can get IP protection for. So I give the example of patents, but you also have exclusions for other intellectual property rights. And then you also have exceptions. So not all use of intellectual property rights will be considered an infringement. So for all intellectual property rights, in most jurisdictions, there will be exceptions for private use or for research use. So you can, for instance, if there is a particular diagnostic tool developed and another company wants to check whether that diagnostic tool indeed works in the way that the patent, that it is described in the patent, and wants to do research on that, that's not an infringement in many countries, not in all countries, but in many countries, there is an exception to that. And also in the TRIPS agreement, you find a ground for that. Also, and that is then more important within the context of copyright, for instance, parodies, or also for libraries, there are special provisions in many countries. So you see that it's very important that you understand and that you take from this class that intellectual property rights are no absolute rights. They're limited rights, they're exclusive. Sometimes people also refer to negative rights, exclusive rights, negative rights, and you need to balance. And there's limitations in terms of time, in terms of territory, in terms of the scope of what you can protect. So that's the exclusions. And also there are exceptions in terms of what you can use those intellectual property rights still for. And there may be differences between different countries. So that is quite important to remember. But the intellectual property rights are there and they are considered important to stimulate cultural and social progress, especially on the copyright side, innovation and technological development, especially also on the side of patents, know-how, design protection, recoupment of investments, basically for all intellectual property rights. Also, the development of the industry, countries also sometimes create new intellectual property rights if that is relevant or considered relevant to stimulate innovation in that country or to stimulate the industry. whether that is desirable or not, creating new intellectual property rights, you can dispute that. So for instance, in Europe, we have sui generis database rights. So that is a kind of variant of copyright protection, but it's really special. It's a special regime only for databases. But this regime doesn't exist in most other countries. In most other countries, people use copyright protection if they want to protect their database. But in Europe, it was considered important for reasons of competitiveness, internal market, to have that kind of sui generis system. And this is not uncommon. If new technologies arise, every time there's a question, oh, should we have a kind of sui generis IP right for this? We now also have that discussion more broadly beyond databases for data as such. Should there be special rights to protect data? Creating more and more intellectual property rights, we should remain critical about that. So yeah, this slide again emphasizes the limited nature of the right. Beyond those limitations, everything is in the public domain. So for copyright protection, the protection is quite long, it's 70 years. But after that moment, the copyright protected work will end up in the public domain. And also, if you decide to protect only in Australia, then there will not be protection in all the other jurisdictions. If you think about rights with a registration requirement, such as patents, such as designs in most countries, if there's no protection in a country, automatically it would be in the public domain. So we're now at slide 19. Can you still see slide 19? Yeah, yes. Okay, good. And so this slide then emphasizes that positive versus the negative nature. So exclusive rights that can prevent others from making, using, or selling the intellectual property without the permission of the IP owner. So if the IP owner thinks, oh, you know, I want to license broadly, I think I can make more money, or I can get a better recoupment on my investment by licensing broadly, then there is permission, and so there is no, the IP owner has decided to use its exclusive rights in a strategic manner by licensing out broadly. And of course, those licenses would need to comply with the block exemption regulation. So IP rights are no positive rights. It's not that if you have an intellectual property right, that you automatically have the right to sell products, because for some products, like again, for medicines, you would still need a marketing authorization. So it's no automatic thing. It's really a negative right. And that is really important, another really important characteristic to remember. Then another characteristic is that often intellectual property rights by itself are not that valuable. One patent, and now I'm at slide 20, one patent is often not what gives the value to your company. You remember the slide that I showed to you in the beginning of Ocean Tomo, the importance of intangible assets. Often those assets come in a portfolio of patents together with some know-how, a few trademarks. So one product is generally protected by a whole set of intellectual property rights. And that's where the value is. And then if you really have a very large intellectual property portfolio, IP portfolio, then possibly you may build your market position on that portfolio thanks to that very strong portfolio of intellectual property rights. But so some people believe that intellectual property rights automatically lead to a monopoly position, but that's not the case. It is possible that if you have a very strong set of intellectual property rights together with a very good business strategy, that you may build a monopoly position, but it's not an automatic thing. It's not given. IP doesn't automatically mean monopoly position or dominant position. And so this is also really important for the interface with intellectual property law. And I think Miguel will mention it again. But so very, very important point to remember. And so today we're focusing on the interface with competition law, but there's also very important other interfaces for especially in the EU, for instance, the free movement of goods, especially a little bit free movement of services too. And there's quite some case law also on this interface between IP and internal market law, the free movements, but we're not going into that. The first time that we were teaching this module, we also had several cases on that interface, but it was too much. So we're really focusing just on the competition law, but remember that those other interfaces are important as well. Of course, we do touch upon intellectual property rights and contract law, because we're looking at licensing agreements and R&D collaboration agreements. There are, of course, also broader contract law questions, which you will also see, for instance, when Miguel will be discussing standard essential patents and some of the issues that relate to the role of standard setting organizations. But you will hear more about that. So you also see there that the interface between competition law, intellectual property rights meets with contract law, and sometimes contract law questions, where some issues are put under the heading of competition law, which are basically things that could be possibly answered better through contract law. But so this may sound a little bit abstract, but you will understand it, if not today, then during the second or the third session. But so I already give you introductions and gives you sorts of connection points that we will discuss more today, Miguel, and also the other two sessions. So intellectual property rights, I've already mentioned a lot, patents, but there's of course many more of them. And you see that trade secrets is here in gray. Because as I mentioned before, they're generally not regarded as a true IP right, but closely connected. But it's more of a semantic thing. What do you call it? So I always discuss them together, because especially patents and know-how are so important, especially also from a competition law perspective and from a business perspective, that I don't want to leave it out just for the sake of the fact that it wouldn't be regarded everywhere as an IP right. So today we will focus especially on the four red ones, copyright, patents, trademarks, and design rights. But in some countries, you also have utility models, very closely related also to patents. I mentioned database rights, the sui generis database regime, for instance, in Europe. Geographical indications, especially important also when you think of the food sector, but also today we will not have time to deal with that. Domain names, obviously also in practice, very important, and plant variety rights also important, but in a very specific sector. So we will focus on the key intellectual property rights, the four first ones, and then also in connection with trade secrets. And so what are these intellectual property rights, or what are the differences? So this is a slide with a lot of words, but let's focus on what you find in red. So copyright is actually focusing on original works, original intellectual creations that carry the stamp of the author. Then patents are especially technical solutions for technical problems. This may relate to a particular product, a material, even genes, but also processes and particular uses. So what you need to focus on there is the word technical. And this is also how the European Patent Office uses this terminology a lot. So what you find in a patent, what is described is the technical features of the technical solution for a particular technical problem. And this is part of the test that examiners at the patent office are using to see whether a patent should be granted or not. Trademarks, for trademarks, what is especially important is the view of the consumer. If the consumer sees a particular color or a particular word, or hears a particular song and immediately links that sign with particular products of a particular company, then that's probably a very successful trademark. Design rights. So often the technical aspects of the invention will be protected through patents, and the visual appearance, the aesthetics, the shape, the pattern or color on top of that will be protected through design rights. At least we, in Europe, we use the term design right. In some countries, they refer to design patents. But I find that quite confusing because you have then the more the technical patents, let's say the utility patents, they're also sometimes referred to, and the design patents. But in Europe, we make the distinction between patents for the technical solutions, design rights more for the aesthetic visual appearance. Really, really important for all intellectual property rights, you cannot protect ideas. It always needs to be more than an idea. And so for patents, trademarks, and designs, this is relatively easy because you need to describe what you want to protect. These are rights that you will only get after registration. But for copyright, in most countries, you don't need to register. You get it automatically, provided that your work is sufficiently original and there is an expression by the author. And of course, that can be subjective. Sometimes people want to protect a website or a style or maybe a recipe. And then the question is this a mere idea? Or is it a work which is original and where there is a concrete expression? And that would then often need to be decided by the judge. So you may have some difficulties there. So we make a distinction between industrial property rights, for which you generally will need to apply and get or register, and then there will be an examination, and then the rights may be granted. And then the more artistic property rights, you could say, where copyright, and now I'm at slide 24, and then IP related matters such as trade secrets and know-how and unfair competition is also often linked to intellectual property rights in that respect. And so this distinction between industrial property rights and the more artistic property rights, it's a little bit old-fashioned because copyright is of course also very important for software. So you may consider this artistic too, but generally it's very functional. Yet their copyright protection is what is used most. In very specific situations, you may get patent protection too, if the software is implemented in a particular application. But most patent offices are quite reluctant to grant patents in that context, but it is not impossible. But generally for software, especially copyright protection is very important. And in particular cases and jurisdictions, you may be able to also get patent protection. But so you have this distinction then between the more technical and non-technical. But really most important distinction is how you get the rights. Do you get it through registration and examination? After examination, the right may be granted, or is there no need for registration, which is the case for copyright? And in some countries, you also have unregistered designs. Also in Europe, we also have, next to the normal design rights for which you need registration, we also have unregistered designs, which are especially also important for instance, the fashion industry, where things are moving so quickly that it doesn't make sense to try to register your designs, but you will actually try to benefit from unregistered design protection. So then if we go to the legal framework for the different intellectual property rights, I've already mentioned in my introduction that there are different levels that are important. If we look at it from the European perspective, which is what I tend to do. And so within the EU, you have the EU that is harmonizing the rules in intellectual property law, but also the European Patent Office is granting patent rights. And so a lot of people think that the EPO is an EU agency, but that is not correct. The EPO is a separate intergovernmental organization. And so it is not bound by what the EU institutions state. So for instance, in the area of patent law, there is the EU Biotechnology Directive. So this is an instrument from the EU where the EU tried to harmonize the approach of member states in granting patents for biotechnological inventions. I see that Miguel is already waiting, so he's quite early. So shall we let him in, Valerie, or we just let him wait? But back to the European Patent Office and the Biotech Directive. So there was an attempt to harmonize biotechnological inventions or the law on biotechnological inventions by the EU. And so in principle, the European Patent Office was not bound by that directive because it's not an EU agency. Luckily, the EPO said, okay, we will include the rules in the EU Biotechnology Directive in our implementing rules. But it's not hard law for them. They use it more as a source of inspiration. So this is quite, from a governance perspective and also an operational perspective, it's important. It's an important difference that it's not an EU agency. Then at the international level, there's also rules that are important, especially
Esther, we don't hear you anymore. Esther, are you there? Let's wait again 2 more minutes, please. Hey Miguel, welcome. We've seen you've been connected. We've had a few breaks with the connection of Esther. So she's coming back to us in a few minutes, but
okay.
So you know she has not left the session for you.
No, I got that. It's like, what the hell is?
Yes, yes. So we think
did it happen earlier?
Yes, it happened once, but we think it's because of the storm and the orange warning in Belgium.
Yeah, I guess that's the case because I can also hear you poorly.
Yeah, for now.
It's not great.
No. Too bad.
Yeah.
Too bad, but no, we'll wait 3 more minutes and she will be joining again.
Okay.
Thank you.
Yeah, no problem.
But you might begin later than expected. That's what I meant.
Yeah, no, that's fine. You know, I'll be here. I'm listening and
Okay.
and I can do
Thank
some other
you.
stuff. Valerie, maybe the best would be to have a 5-minute break for everyone.
Yes, I think yes, you're
No?
right.
Yeah.
No. Let's meet again at 10:03 Brussels time, if that's fine for everyone. See you.
Yeah.
Thank you.
Okay, Valerie, I think I'm back.
Yes, you're back. Yes.
So did you tell people that we're taking a break?
Yes, everyone is in break until 10 past 3. So,
until what time?
10 past 3.
Okay, super. Yeah, I hope I will not be thrown out again because the weather is really bad here.
Yes.
And I read that it will be until 4 like that. So exactly until when I will be talking. So that's very convenient.
No.
But so also here in the street, several houses got flooded. So I hope that while I'm talking, our cellar is not being flooded. But anyway, I will also take a small break then and get some
Yes.
water, and we'll be back in a few minutes. And let's
Yes.
hope it will be fine then.
And let me know if you want me to share the slides because you are afraid of the second break. That's something I can do as well for you.
So you're sure that you will stay until during the whole session?
Of course.
Yeah. Okay. Yeah, maybe that's better. So if I put off the camera, but you only have the PDF, huh?
Yes, that's true.
But I don't think I have so much animation on it, so then it doesn't matter that much.
Okay, I can try.
Maybe it's better.
Okay. Voila. No. Do you see my screen? No.
Yeah.
You see the slides? Right.
Yeah, I see the slides. Yeah. we were at the legal framework?
26.
Something like 26 or so, I guess.
Yeah. Do you see 26?
Yeah, I think we can go to the next one. Yeah, even further. Yeah. This is where we could start after the break. Okay.
Let's work like that until the end of your session to make sure that you stay with us.
Yeah, I think it will be, yeah.
Okay.
It will be better if I don't have to share the presentation, I think. And then without the video.
Yeah.
Let's give it a try.
Yes, and take the time now if you want to get something to drink before.
Yeah, I'll get some water.
Worry.
Thank you.
Yeah, sure.
Hello, everybody. Can you hear me? Eve, can you nod if you can hear me? Ah, yeah, until, thank you. This is great. Yeah, so it was time for a break anyway. So it was not such a big problem that I was gone. And in the meantime, also Valerie and me, we made a new arrangement. So to be sure, I'm keeping off my video. And Valerie is sharing her screen with the PDF. And so Valerie will be changing the slides. So let's hope that my connection will then be a little bit better and that we will not use any more time with technological issues. Because also Miguel has a lot to tell you. So we need to make sure that he can start at 4. But before I start running through the slides again, because I know I talk quite quickly. So if I go too quickly, you can always raise your hand and let me know. But are there any questions at this point in time in terms of the special characteristics of intellectual property rights or the broader context in terms of innovation or also the different instruments and how they interact? Are there any comments or questions on that? So if you have comments or questions, you can either put them in the chat or you can raise your hand. And by the way, you can also do that while I'm talking. You don't have to wait until I ask whether there are any questions or comments. So for now,
I have a question.
Simon, go ahead.
I have a question regarding the licensing agreements, because this is the question I always wanted to ask, honestly. Licensing agreement, which is typical for the IP rights, for the IPR system. This is limited in scope. I mean, as to the areas of exploitation and as to the territory, and as to this second part, limitation in terms of territory. Licensing agreement as the agreement, being the agreement under 101, could be also assessed in the light of criteria laid in this provision of the treaty. And how do the territorial scope of the licensing agreement, does the territorial scope of the licensing agreement could be a territorial restriction under competition law, and how these two things work together? Because I have always problem with this issue.
Yeah, so this is a very good point. So indeed, licensing agreements. So of course, like with all contracts at the beginning, you will often have some kind of preamble or not, and you will have definitions and the scope of the agreement. So there will be a description of the material scope and the territorial scope. And then often also there is an annex or there is a related list where the relevant intellectual property rights would be listed. And as intellectual property rights are territorial in nature, so it's important to identify exactly which intellectual property rights would be covered. So already automatically there is some kind of territorial limitation because of that is inherent in the intellectual property rights. But of course, also in competition law, the territorial limitations are a point of attention. But so there are special provisions on that also in the block exemption regulation. And Miguel will already go into that today in his introduction in the next part. And also next week, we will discuss more about it. But it's not that the fact that there is some kind of territorial limitation that is automatically problematic. It depends how that is being set up. So now this sounds still a little bit abstract, but it will become clearer when Miguel is explaining that, and we will also come back to that still next week. But so territorial as such is not necessarily a problem, because because it's logical, because the intellectual property rights are limited in nature. But then you also have kind of the passive limitations, etc. And so this is, it goes a little bit too far for me now to develop that further. But let's also listen to Miguel after the next break. And we come back to it next week. And then if it's still not clarified, we will definitely also come back to your question, Simon. Is that satisfactory for now?
Yes.
But I understand your confusion and the fact that it seems weird. Is this something that is really allowed? Isn't this automatically anti-competitive? No, as such, not necessarily, but it depends how that is actually set up. So we will come back to the details later on. But thank you for mentioning that, because it's an important point. Are there other questions at this point in time?
Yes, Professor, I have questions about the IP law and the contract law, because I have read some judgments, because in China, for example, Huawei or ZTC, they will ask the PIC court to determine the loyalty, because the loyalty asked by the SCP hold may be too high. So they want to apply to the PIC court. Maybe the PIC court usually give a very lower loyalty to them. So my confusion is that even though the court has determined the loyalty, for example, $1 or some dollar, but it doesn't mean it necessarily that will be a licensing agreement between the holder and implementer. So that maybe I'm very confused. So when they come to the licensing agreements, when the court determine the price or when the party size.
Yeah, so this is of course a very important point, and I've already also mentioned in the introduction that the standard essential patents are a core theme in this module. Also something that I think today Miguel will touch upon, but definitely also next week and also the third session. Typically an IP owner can decide on the price. Normally, in normal circumstances, this is freedom of contract, and an IP owner could set the price, and then the other side could simply accept it or not accept it. But within the context of standard essential patents, this is more complicated, and there has been different decisions also, because there is an obligation to comply with conditions that are fair, reasonable, and non-discriminatory. So you need to comply with friend terms. And what does that exactly mean? Nobody knows. But so this is the price that needs to be set. And so this is where then courts step in particular jurisdictions, and sometimes come to different decisions. But so this whole complexity regarding friend terms, this is also something that you will hear much more about from Miguel. And also focusing, I think, on the EU, but he's also referring to decisions of different jurisdictions. So also there, but I fully understand that it's confusing you. And that also the fact that there are different decisions in terms of the injunctions, because normally in normal circumstances, an IP owner is not only capable of setting the price and deciding on the licensing conditions, but also capable of deciding not to license. But in particular circumstances, that would be regarded as a refusal to license. And again, within the context of standardization, that is a particular challenging topic, which requires much more time than I still have, because I just have 40 more minutes before Miguel will touch upon this. But I'm sure you will you will get more clarification from Miguel on this point. But normally, indeed, IP owner could set this price, and it's up to the parties to decide this. But in particular circumstances, the court will intervene And then there are complex legal questions related to the FRAND terms, and then also with respect to granting injunctions, yes or no. But we will come back to that in great detail. Okay, so if there are at this point in time no other burning questions, because the question from Vivian is burning, I understand, but it is very specific and will be elaborated on much more later on. So for now, I continue a little bit more with my introduction in the different intellectual property rights to at least get everybody on the same page in understanding what IP rights are about and what are the differences. And so going first into copyright and the harmonization at different levels. So I hope that from my introduction, you remember for copyright, generally in most jurisdictions, you don't need to register. You have the right once the work is original and there is a concrete expression. So for instance, in the past in the US, registration was required, but now in most cases also in the US, in order to get copyright protection, it's no longer required. But so in most jurisdictions, that is now the case. In Europe, we do not have one directives that deal with copyright law. We have several directives that deal with very, very specific topics in copyright law. Which means that it's very fragmented and that the national legislation in terms of copyright law is still very important. There are two directives which are especially important within the context of the digital society and also for intermediaries, which is the InfoSoc directive from 2001, which you see listed here on slide 28 as the first one. And also the Digital Single Market Directive, which is now often referred to as the DSM directive, and which is part of the same package basically as the DMA and the DSA, but a Digital Single Market Directive within the context of copyright law is especially also focusing on the role of intermediaries, the role that intermediaries have, for instance, in ensuring that there is no infringement. They have all kinds of monitoring and filtering obligations with respect to illegal or content that is copyright protected and put on the internet by people who didn't have authorization to do so. And so what they try to do through this directive is giving more obligations on all kinds of intermediaries, such as YouTube and Google and others, to intervene and to actually remove content, illegal content. But that then has an interface with freedom of expression, and sometimes content by the algorithm is regarded as illegal. But if you would look into copyright, it would be used, it would fall within the scope of one of the exceptions, such as private use, for instance, or a parody, but the algorithm didn't recognize that there was a parody. So this is quite controversial. And even though this is a directive from 2019, which had to be implemented in national law by now, in a lot of countries, the implementation is still ongoing. There was also, maybe interesting also for you, Simon, there was also a challenge from Poland of this directive, which very recently by the Court of Justice was rejected. But a very important and controversial case in terms of this Article 17 of the Digital Single Market Directive in terms of the monitoring and filtering obligations for intermediaries. So a lot going on in this area, but no real systematic harmonization at the European level. It's very fragmented on very specific topics. And so what we see is that the Court of Justice has been very active and that there's a lot of case law of the Court of Justice on the bigger principles of copyright law. For instance, what is originality according to EU law? And what are the obligations for users, and when is something considered an infringement or not, also when you use particular links. So there's a big body of case law from the Court of Justice in the area of copyright law, which is also playing a very important harmonizing role. And so you also see one directive from 2009 with respect to computer programs. So that is also quite important, but as I said, and I want to emphasize, very fragmented. Valerie, I think we can go to the next slide. So what you then see in copyright is you can protect many, many things, all creations in the literary and artistic domain, and also beyond that. So also software and compilations of data, and also technical protection measures, such as certain types of coding, passwords, locking, all of that can be protected through copyright protection. So a lot of people, they just think of music and literature when they think of copyright, but over time, especially the last few decades, this has been extended a lot. And so it's very, very broad. So this is what this slide is showing you. In the red box, you see the more, let's say, traditional examples. And then under the second bullet point, you find this gradual extension of the concept of work, which is very important within the digital context, of course. Valerie, we can go to the next slide. And so for you will see in these slides for copyright patents, trademarks and designs, I always use the same structure. So first I deal with subject matter. What kind of subject matter can you protect? Through copyright protection, through patent protection. Then what are the minimum standards? So what are the requirements that the work in this case or the invention needs to comply with? Are there certain exclusions? Are there certain objects that cannot be protected? Are there certain exceptions to those rights, such as private use, research use, and the kind of balancing that is needed there? And what kind of rights do you have as an IP owner? But in my slides, I always use the same structure. So here we are now for copyright with the minimum standards. And so what are the two key criteria? I already mentioned it a few times: originality and concrete. So what does originality mean? Of course, this is also different in different jurisdictions. So as the rights are territorial, also the copyrights are territorial, you would need to look in the particular jurisdiction where you're practicing what it actually means in practice. But in EU law, what we focus on, and in many EU countries, we look at the intellectual activity of the author, the stamp of the author. There needs to be the intellectual creation of the author needs to be recognizable in the work. And so this is coming from the Court of Justice. This is harmonized. This is an autonomous EU concept, as the Court of Justice refers to it. And so there is some case law of the Court of Justice in that respect. Does original mean very high quality, or does it deal with the aesthetic merits of the work? No, that is not relevant. You may like a certain work or you may dislike it. It may be copyright protected no matter whether we like it or it's high quality or low quality. So if I would, during the break, if I would have written a poem and it would really carry my own original stamp, it would be, I would be using special words that I have invented myself, I have come up with myself, then I have a copyright. Whether it's really low quality, high quality, doesn't matter. Certain notes taken by students, there may be originality in that too. So you quite easily fulfill the criterion of originality. For expression, the idea is that you need that you cannot protect ideas. As I mentioned before, it needs to be something concrete. So just a style or a technique or a company that makes websites in a particular format or style, you will not be able to protect that style or format. So that is an important distinction point. Valerie, we can go to the following slide. And then what is also interesting for copyright protection is that you have two sets of rights. You have economic rights and moral rights. In some countries, these moral rights are not considered so important, but in the EU, especially on the continent, on the European continent, there is a lot of importance attached to the moral rights of the authors. Sometimes copyright is also referred to as authors' rights. And so you cannot just change a work of an author. You cannot modify and affect the integrity of the work. That is only the author who can do that, or somebody who is authorized by an author to do so. So this goes really quite far. So architects who in many in many countries also have moral rights to not only the building design, but also the building itself, could prevent the owner of the building from modifying the design of the building. So that, just to give you a concrete example, that those moral rights can go very far. You also have the right to be mentioned as an author, or the right not to be mentioned if you don't wish to be mentioned. You also have economic rights, which are, of course, also especially very important within the context of software, but also, for instance, for music as well, and for other types of works. And there you have an element of reproduction, and also the communication to the public, which normally can only be done by the author, or in a way which is authorized by the author. So those two sides of copyright are really specific for copyright protection and quite important within the context of IP law. Is this so important for competition law? For competition law, primarily the economic rights will be of relevance, because that's what you will find in the licensing agreements. That's what you will find in R&D collaborations that, for instance, deal with important algorithms that are being designed, software that's being developed. Okay, Valerie, we can go to the next slides. And so typically, as I said before, intellectual property rights, they are limited. We need to interpret them in a narrow manner, and they are an exception to the basic principle of free competition. But there are also exceptions to these exceptional rights, to these exclusive rights. So as I mentioned before, you can use a right, for instance, for a parody, or if it's technically necessary. Yeah, so you can imagine in terms of uploading and downloading certain works, there are certain temporary files that are important in order to enable that. So those kind of technical necessities can also follow under some of the exceptions that, for instance, you find in this InfoSoc directive that I mentioned before, which is an important directive at the European level. So in copyright law, in national law as well, you find many exceptions to copyright protection. So this is again why I ask you, don't look at intellectual property rights as absolute rights. For all these rights, there are exceptions, and here you find some examples of the exceptions relevant for copyright law. Valerie, we can go to the next slide. What is also important is, for instance, this C sign, the copyright sign. So a lot of people also believe that if that symbol is not included, that you don't have protection. So that is not true. This symbol generally just has a kind of symbolic or a kind of signaling and warning function. So also if I write an article and I don't include the copyright symbol with my last name, I would still have copyright protection. So this is relevant for practical reasons, signaling reasons, and some deterrence as well. But you're not dependent on it to be able to actually invoke your rights. Okay, we can go to the following slide. So are there any questions on copyright? So this is relatively basic. So I'm not going to go into very concrete cases. There's lots of cases at the European level, national level, different jurisdictions, but we don't have time for that. I just want to give you a good understanding of the structure of the rights and the limitations of the rights and give you different examples of that. So any questions about this? Charlotte, is it not too boring for you? No? Okay, because you said you have already more experience with IP law, so I hope I can still add some small things here and there.
Yes, you can. Thank you.
Okay, good to know. Okay, so then we can move to patents and the legal framework for patents. So here I already mentioned Paris Convention. You see, this is a very, very old treaty from the 19th century. So this treaty is not made for stem cell protection or a protection of gene sequences. Valerie, I think we're now seeing your screen moving to something else. Don't share confidential information. But this Paris Convention and the same for the Berne Convention, these are really old conventions that are administered by WIPO. But a lot of the big principles are still valid today. And so you see also in IP law that there's a lot of broad concepts that are being used. So invention, novelty, inventive step, those are very broad concepts that you find in national legislation, the European Patent Convention, international treaties, but they of course have developed in terms of how they are interpreted and applied in practice over time. The inventions of steam engines in the 19th century, the beginning of the 20th century, that's a very different story from the technology that we're looking at today. And so you will understand that most of the people who actually apply for patent protection, the patent attorneys, and also patent examiners at IP offices, these are people with a very high level scientific background. And so mostly these are not IP lawyers, but these are scientists who have studied patent law. Here and there, you may find a patent attorney who doesn't only have a scientific background, but also a full-fledged legal background. You see that more in common law jurisdictions. So also for Sonia's point of reference, because so in European countries, generally, you can easily just go to law school and don't have another degree. But in certain jurisdictions, people have already another degree when they would go to law school. And those people who would like to specialize in IP law and specifically patent law will, in those countries, often have a scientific background, or a background in economics can also be very valuable. But so what you see in most European countries, those people who practice as a patent attorney or as an examiner at an IP office, they will be scientists with a specialization in patent law, and sometimes also a legal degree, but that is rather more exceptional. And this is because the science is actually so important to be able to make the analysis of novelty and inventive step. You need to really be able to understand the science very well, to be able to understand the technical problem, the technical solution that the inventor has come up with, and to also describe the specific technical features of the invention in the patent application, in the claims of the patent application. So just as a remark, so that if you will be working in practice with patent attorneys, or involved in dealing with an IP office, many of those people will not have a very extensive legal degree, but have a very, very extensive scientific background and a specialization in patent law. So again, I emphasize for Europe, the European Patent Office is a very, very important actor in granting patents for Europe, for many European countries. But the EPO is not an EU agency. So for instance, also Switzerland is a member, the UK is also a member to the European Patent Convention. So this goes beyond the EU. The EU also wanted to have an EU patent for a long time, just like there's also an EU trademark and EU designs, but this has been very, very difficult. And in 2012, the unitary patent package was adopted. because the current system with the European Patent Office has some disadvantages, because there is a centralized application procedure, but once the EPO has decided that the invention is novel and inventive, you will get not a complete European unitary title. No, you get a bundle of national patents. And if you want to enforce your rights, you cannot go to the EPO. You would still need to go to many different national courts. So the system as it is now is still very fragmented. So it's a European Patent Office with a European Patent Convention, but the actual title that you have is a combination of many national patents, a bundle of national patents, which makes it a very expensive system, more expensive than, for instance, in China, in the US, and in many other important jurisdictions. And this was an important reason for the EU to say, we need to have a true unitary title. This has been very difficult. It took them decades to come up with the patent package. And in the end, for different reasons, not all member states wanted to agree on this. So this is why the unitary patent package, not all the EU member states are participating. It's an enhanced cooperation process. And I will not go into all the details, but it's important to know that not all EU countries are participating in this. And so we still end up with a rather fragmented system, even though there will be, we use the term unitary patent, and there will be a specialized unified patent court. It will still not be fully uniform. So this is an additional complexity at the European level, where there will remain these two actors, the EU and the EPO. They will need to collaborate within the context of the unitary patent. But there is a lot of governance challenges, and so it has also been taken very long for countries to ratify this. For different reasons. There were different constitutional complaints in Germany against the patent package. But now people think that probably by the end of this year or beginning of next year, it will enter into force. But this is still uncertain. So and of course also Brexit has made it really difficult, because the UK is a very important country in terms of patent jurisdictions. Just like Germany, France, also Italy, the Netherlands, it's a small country, but in terms of relevance from a patent law perspective, also quite an important jurisdiction. If you have further questions on the patent package, maybe we can talk about it during the break, because I need to continue because Miguel is waiting. So Valerie, let's go to the next slide. So here, this is the slide on subject matter. So you remember for copyright law, there were many things that you can protect, which are considered a work, and it has been extending over time. So if you look at patent law, both in the TRIPS agreement and in the European Patent Convention and in other countries, generally this is phrased very broad, any invention in whatever sector. So even though, as I said earlier, in the past, in some countries, you couldn't get patent protection for medicines, this kind of discrimination of a particular sector is now no longer possible, unless you're in developing countries and you fall under a transition regime. But so normally inventions in all sectors can get patent protection. This can be products or processes, as long as there is something technical to it. And this is, of course, where you have some controversy when you think, for instance, of biotechnology. These are often natural products or processes, laws of nature. That's a term that is being used in the US, for instance, in the case law, where there is quite some controversy as to whether this should be patentable or not. Valerie, we can go to the next slide. But so technical is really the key term when you think of patents. And so if you then look, for instance, at patent discoveries, scientific theories, mathematical methods cannot be patent protected. Also, programs for computers cannot be patent protected. You find that under C. Presentations of information, neither. So you would think, oh, programs for computers, that means software cannot get patent protection. But this is strange because Esther said before that in very particular cases, you can get patents also in Europe for software. And this is in the word in the final word that you see in this slide, as such. So you cannot get patent protection for programs for computers as such, neither for discoveries and scientific theories as such. But if you go beyond the mere program for a computer or a discovery, and you are a smart patent attorney that is well in drafting very precise claims, then for particular implementations or particular technical solutions within the context of that discovery, you may be able to get patent protection. But this case law and these principles are quite controversial. So there's a case law in many countries about the patentability of software, of business matter, business methods, living matter, such as human gene sequences, and also, for instance, the CRISPR technology, genome editing, you might have heard about it. mRNA, within the context of COVID, we've heard a lot about it. So also there is some discussion whether a lot of those very key platform technologies, whether they should be patent eligible or not, and not all countries agree on that. Okay, Valerie, we can go to the next slide. And so apart from that list of exclusions in the European Patent Convention, a lot of countries also have other grounds which would justify an exclusion from patentability. And this is not only relevant for Europe, because these grounds also are included in the TRIPS agreement. And so also in many other jurisdictions, you would find those exclusions. So inventions which would be contrary to public order and morality cannot get patent protection. So what kind of cases are relevant then? Think, for instance, of stem cells. In some countries, stem cell treatments would be considered problematic because, especially in the past, you would need to destroy a human embryo in order to be able to actually get the stem cells for which you were developing or what your invention is based on. So there's case law on that in different countries. Also, essentially biological processes. So for instance, in Europe, we have cases such as the famous tomato and broccoli cases, where this ground for essentially biological processes was also very important. So just to give you some examples that show you again that patents are no absolute rights. There's a lot of things which are excluded and for which you cannot get patent protection. There's a lot of exclusions and exceptions already in patent law. And then in addition to that, competition law also limits what IP owners can do. And this is what we will learn much more about also from Miguel and the next two sessions. Okay, Valerie, we can go to the next slide. And so what is really very, very important for patent attorneys and patent examiners in then deciding, is the invention really novel? Is there an inventive step? So from the perspective of what we call a skilled person in the art, so really a scientist with knowledge in that particular field, whether it's an engineer working more in the area of ICT and software, or somebody who has a specific knowledge in material sciences or in biomedical sciences. So from that perspective of this person skilled in the art, they check whether, based on what we already know, the prior art, based on that prior art, is it inventive to come to this new invention? So that inventive step is a very, very important concept in patent law. And then industrial applicability, that's not such a difficult requirement. Most inventions, even cosmetics, etc., they could pass the criterion of industrial applicability. criteria is actually not doesn't have such a high level of restriction. What is very important is that you also describe very clearly what your invention is about. So that is the disclosure requirement. So a lot of people think, yeah, what IP patent owners, they have these very broad rights, and nobody knows what is really protected. No, you can actually go to the database of the European Patent Office, the USPTO, Australian IP Office, and you can search for relevant patents. And those patents need to disclose very clearly what is protected by the patent owner. And so that disclosure function of patents is also very important because it allows others to learn from what is already out there and to learn about those technologies that are protected through patents. So there are all kinds of quid pro quos within the patent system. And in addition to that, also IP owners need to pay very high fees to have those rights. So it's not a given, it's not a right that you will easily get. There is first quite some high step that you need to pass in terms of novelty and inventive step, and also the exclusions that I mentioned before. And then during the 20 years that you want protection, you also continuously need to pay fees to maintain your protection. If you stop paying the fees, your invention ends in the public domain and everybody can use it. So that's again this limitation that I referred to many times already. Okay, Valerie, we can go to the next slide. And so the claims are really key. So the patent attorney, together with the inventor, will sit down and will describe what the patent is about in the claims. And there are then different types of claims, but the claims really decide what is the scope of the patent. Is it a very broad patent? And there I can refer again back to this kind of radical innovation. Is it a huge jump, a new invention, a completely new type of product? For instance, when different universities in the US were developing this genome editing technology, this CRISPR technology, that was a huge invention, a really big step, a completely new platform technology with many different applications. So what the universities then try to do is describing that in relatively broad claims. So they have also really very broad protection. But in many cases, those claims will be very specific. And also it's the task of the patent office to ensure that patent owners get only protection for what they have really innovated and not going beyond that. So they're very critical in checking the claims and checking whether what is disclosed is really what the invention is about. Okay, we can go to the next slide, Valerie. And here you find the rights. So this is also important from the perspective of the licensing agreements. This is a provision of the TRIPS agreement, where it's described then if the patent office decided to grant the patent, what can the patent owner then do? The patent owner can make use, offer for sale, sell and import the product, but can also decide to assign a license. And so in terms of those licensing agreements, R&D collaborations, which is what is relevant also from a competition law perspective. Not only the TTBR, also other block exemption regulations are relevant there if you look at other types of agreements. But you see that the IP owner has a broad bundle of rights that he or she can use. Okay, Valerie, we can go to the next slide. And to those rights, there are, just like we have seen for copyright law, exceptions. So for copyright law, we saw parody, we saw private use, we saw libraries, citations, certain measures that are technically necessary. So also for patents, there are such exceptions for experimental use, research use. So even if in a particular jurisdiction there is patent protection, universities will still be able to do research regarding that invention. Not in all countries will universities also be able to use the invention to do the research, but they can check whether the invention is really operating in the way that it is described in the patent. The Bowler exception is a very particular exception which is relevant in the pharma sector. I will not go into the details. If you're interested, you can let me know and I can send you some specific information on that. Valerie, we can go to slide 42. Thank you. And so in terms of the procedure, yeah, I already mentioned this in the beginning. We can skip this slide, Valerie, and go to the next one. So this is about this this ambiguity and complexity in Europe, where you have on the one hand this unitary patent package, which didn't yet enter into force completely, but will likely do so either end of this year or beginning of next year. And then it will lead to a very big change in terms of patent strategies, and people who have European patents or who want to apply for protection in Europe need to think very carefully whether they want to have in the future European patents or whether they want to shift to the regime of unitary patents. So that is strategically and business-wise really important when the unitary patent package will enter into force. A lot of decisions that will need to be made and that IP owners are actually already making in preparation for the unitary patent to enter into force, together with all kinds of experts, and then this kind of collaboration that we will need between the EU and the European Patent Office to actually make that possible. Any questions about patents? I don't immediately see any hands, so we're just finishing then the last slides related to trademarks and design. So I will not go through all these different agreements step by step, but just to show you that also for trademarks, there's a lot of harmonization. Several treaties at the international level, also very important directive and a regulation at the European level, and so especially the community trademark, which nowadays is called the EU trademark, is a very, very important tool. So different from
Okay, I see that Esther has just left us again. I'm just checking how many slides are left. Okay, still 15. Miguel? Yes. Miguel? Yes. If you're there. Wow. Let's do 5-minute break again. Let she come back. I'm sorry. At least you will have some breaks today. No, but she's coming back. So let's wait.
Valerie,
Yes, Miguel. Yes.
can I then share my my presentation?
Yes, of course. No, I will stop sharing, and if you want to start, then I suppose that Esther can continue for the next session or something like that.
I was asking whether I will be able to share my my presentation instead of sharing the screen.
Yes, but that's both. You can do both.
Okay.
Um,
It's just that I don't see here the option yet of sharing a presentation.
yes, it's below in the bar. You have a green.
No, I just have the sharing the screen. I don't have the share.
You have to open your slides and then choose the screen that you are sharing. But before,
Yeah.
you have to open in full screen your slides before that.
I'm just going to test.
Yeah, you can try it now if you want.
Did she message you that she's coming back, or is she
Not
still having
yet. Not yet.
still having Wi-Fi issues?
Oh yes, I'm trying to return. Okay, that's good. It never happened. I'm really sure it's the storm. I see a lot of wind outside, so.
Well, I had no wireless connection earlier on my.
Oh my God.
Yeah, so.
Great. Mm. I don't know if you are trying, yeah, or not. Here is Miguel.
Yeah.
Are you trying to share your screen?
No, I think it works. Yeah, I think it works. Let me see.
Okay. Yes. Yes. Okay. Perfect.
It does work. So.
Yes. Great. Video. Okay, so Esther is joining. I stop your sharing, Miguel, so you can share again Esther slides.
Okay,
Hey Esther,
I think
welcome
I need
back.
to finish really quickly and then just hope that Miguel will not encounter the same difficulties. I just have a few more things that I want to say so that Miguel can start immediately after me. Could you go back to the slides?
Yeah. So.
I never had it this bad with the
No,
connection.
no, me neither. But I see it's very windy outside and.
Yeah, so really my apologies to all. Yeah, I think most of what I wanted to say has come across relatively clearly, I hope. And otherwise, people can always ask me still some questions. In terms of trademark law, so I already explained at what level and the importance of the EU trademark and the fact that the EU IPO is granting those rights, and that for the Benelux, there is also a Benelux office that can grant trademarks. But as the EU IPO is so successful and the prices are relatively low, so it's much more interesting to actually get an EU trademark with jurisdiction in the whole of the EU. And so unless you're only active very locally, then national trademarks or Benelux trademarks may be useful, but more and more companies immediately go to the EU IPO to get trademark protection in the EU. And then in most jurisdictions nowadays, just like we have seen for copyright and patents, the subject matter that you can protect has been expanding over time. So traditionally, trademarks were especially used for words or maybe slogans, maybe a logo. But more recently, you also see extension to 3D trademarks, so more the shapes. And the typical example there is the Coca-Cola bottle or the chocolate, the Toblerone, but also colors, sounds and smells and combination marks. But those less traditional trademarks are often harder to get, because what IP offices also want is keeping those free also for others. And a particular color, if you give it as a trademark, even when it is for very specific products and services to a particular company, then others will not be able to use it anymore for the same products or for very similar products. So this is why in terms of colors, sounds, and smells, in most jurisdictions, it's harder to get trademark protection for those kind of signs. Okay, let's go to the next slide. So also here you have certain minimum standards, you have certain criteria. A word may not be descriptive. It can also not be too generic. It really needs to be distinctive in a particular way so that consumers link the particular word or the logo immediately to a particular product, to a particular company. And so that link in the mind of the consumer. And then in most cases, this is the average consumer, but if it's for very particular types of services or products, financial services, it may not be the average consumer. It may be a more specialized audience that is taken into consideration. Also, there is an exception for public order and morality, but that is in most countries not used that much. Okay, let's go to the next slides. And then trademark owners can prevent, of course, others from using the trademark unless they have the authorization to do so. So, for instance, distributors may be able to use the trademark often. That would also be included in the distribution agreement. Also for franchise agreements, this may be really important. But all the others, the trademark can prevent, all other third parties can be prevented from using the trademarks for similar goods or services, or firstly identical goods or services, but also similar goods or services. But what then, to what extent that would create a likelihood of confusion? Again, that is up to the courts to decide. And there is a quite divergent case law in different countries. And even at the Court of Justice, if you look at the interpretation, some people also see that the Court of Justice is also not really always as consistent and coherent as it should be. So, but this is what the trademark owner can protect against. And there's, in many jurisdictions, there's also other grounds that a trademark owner can invoke, but I will not go into all those details, just that you have an idea of that. Okay, Valerie, next slide, please. There's also exceptions, like we've also seen for copyright and patent law. So IP law is quite logical. The structure is always the same: subject matter, requirements, exclusions, and exceptions. And so here you can use the trademark. For instance, if Esther, my first name, if that is also used, if that it would be also a trademark for a particular company, I would still be able to use it as a name. And that's kind of logical. But so in trademark law, those exceptions are kind of obvious. Nation of the goods, if it indicates the value, there's still a lot of things that you could use, especially trademarks that are less distinctive, that you can still use them for. Okay, next slide, please. And trademarks, you also need to register. And the same as for the C symbol with copyright, if there is if the symbol is used, that is not really creating the trademark. It's more of a signaling function, a warning function that is really fulfilling. For trademarks, different from patents and copyright. So for copyright, the maximum term of protection in Europe and in many other countries is 70 years after the death of the author. For patents, it's 20 years. For trademarks, there is no limitation in time, provided that you're continuously paying the fees. So that is different from the different intellectual property rights. So here, the limitation in time only exists when you are no longer paying your fees, your maintenance fees for the trademark. Okay, next slide, please. And here this is just a slide with some examples of the most important trademarks, the most important brands in 2020, just for your information. We can go to the next slide. And design rights. So here again, harmonization at different levels, including also Benelux, but also a very important harmonization through a directive and a regulation. So where you really have unitary design protection at the level of the EU. Next slide, please. And what is important, like I said in the beginning, so it's the appearance, the aesthetics. And so you cannot get design protection for something which is technical. And this is important for the intellectual property rights, is they all have their own function. So patents deal with inventions, with technical issues. And so that kind of distinction between what you can get protection for is also really important. And you see that there's also a lot of case law where, for instance, companies try to get protection through copyright for something technical, or through design rights for something technical. This is not how IP law is intended. And so most courts will be really strict in that respect. Okay, next slide, please. And here you also have as a minimum standard novelty, but it's not the same as novelty for patent law. So in patent law, it's really novelty. Do you already find it in the prior art? Here, is there no design identical or differing, and only very small details available to the public. So it's a slightly different understanding of the concept of novelty. So again, that's a little bit tricky, that we use the same terms for different intellectual property rights is not always so helpful, but individual character is also a very important criterion for getting design protection. Okay, next slide, please. We're almost there, and then Miguel can go. with the really important stuff. So just like for all the other intellectual property rights, also here you have the rights with particular exceptions. So also for private use, for non-commercial use, experimental use, those are all things that third parties can continue to do even though there is IP protection. Okay, next slides. And for design rights, generally you would need to register those. Can also happen at the level of the Benelux. But in the EU, you also have the unregistered design rights that I mentioned in the beginning, which are especially interesting for sectors where you don't need very, very long protection period, such as, for instance, fashion. Next slide, please. Then I briefly want to mention trade secrets. So trade secrets are not truly IP rights, but they're very, very important. So what can you protect through trade secret protection? Only things that are really secret. So the holder of trade secrets also need to make a big effort to keep things secret. So that means that, for instance, not all employees will have access to the know-how. Only on a need-to-know basis. So only the employees that need to have particular know-how to be able to pursue a particular process or to manufacture a particular product, that is the knowledge that you have, but it shouldn't go beyond that. What is also important is that effectively, the fact that it is secret, that is what gives the value to the know-how that is protected through trade secrets. And so, as I said before, you really need to make many steps by putting things behind all kinds of encoding and passwords if it's really, really very valuable know-how that you want to keep secret. And so in Europe, there were big differences between different member states and how they were protecting. In some countries, it was through criminal law or sometimes through specific legislation through other IP rights, but so now this has been harmonized since 2016. Okay, next slide, please. And then in terms of the optimal design, so this is really the last part. So this is strategically very important. A lot of decisions that companies need to make in terms of the costs. You have seen that many of the intellectual property rights need to be registered. That has a cost. The registration process has a cost. Writing patent claims or also preparing the trademark application. You need experts to do so. That all has a cost. Also thinking about the duration. For how long do you want to pay the fees? That's not only legal considerations, but a lot of economic considerations as well. The scope of the patent, the scope of the claims of the patent protection. And then if you have the rights, do you want to enforce them? And if so, or if you want to exploit them through licensing, to whom will you do that? So it's also very important to think about the conditions under which you want to license, which is of course also a key question for the block applicability of the block exemption regulation and the compliance with it, and a lot of the cases that we will be discussing with Miguel and also the next 2 weeks. Next slide, please. Then what you see is that over time, for all of the intellectual property rights, there has been a gradual expansion of the subject matter that can be protected, and also in some countries in terms of the duration. So for instance, for copyright, now in some countries, it is 70 years. In the past, it was often 50 years. And you see that there's a push, there's lobbying trying to expand both the subject matter and the duration of the protection of various intellectual property rights. Yes, next slide, please. And so this is the end. And so I hope that I have been able to show to you that the importance of intellectual property rights has only been growing over time, that in a particular sector, but basically in all sectors, also this interface between IP and competition law is really important. that this context of innovation, which is a very dynamic environment, brings along particular challenges from a competition law perspective. For instance, in terms of defining the market, also looking at the conduct of companies, which may be very important for building a strong position in a very volatile and new market. So those kind of questions in terms of definition or of market definition and concepts such as dynamic efficiency raise particular challenges in at this interface with intellectual property rights. And then I hope that I have also been able to convince you to talk about exclusive rights and not about monopoly rights, because especially if you work in competition law, this is a very, very confusing concept. So try to stay away from that, and don't see patents and other intellectual property rights as a kind of absolute right. Only if you have a strong portfolio with many other features, you might be able to build a dominant position on that portfolio, but it doesn't give you automatically some kind of monopoly. So that's, I think, a very important lesson to take from this lecture. Next slide, please. I think it's that should be the last one. Yeah, we will go over this and maybe come back to that next week. So thank you for your attention despite all the technical challenges. And now I just leave it to Miguel to see how he wants to organize the rest of this class. I will try to stay in the session if Zoom doesn't kick me out again. So if you have questions for me later, I will be available. But also the next 2 weeks, we will see each other and there will be other opportunities to ask questions.
Thank you very
Miguel,
much, Esther. Thank you. Yes, Miguel, let me know if you need any help sharing your screen. Ah, voila, it's already on. Great. Thank you.
Can you guys hear me?
Yes, perfectly. Thank you.
All right. So I was going to ask you, when shall we have a little break? At what time, so that I can time it?
Up to you. I will let you decide. I would say 5, but really, if you have a lot to say, it's up to you.
Yeah, no, I was wondering when did we have the prior break? Just half an hour ago, no, or 40 minutes. All right.
Yeah.
Okay.
Yeah, we had an additional unnecessary one, which was due to my technical difficulties. Sorry about that. Sorry about losing a lot of time, Miguel.
No, no problem. That's okay. That happens. I hope it doesn't happen. I hope it doesn't happen to me. All right. So I'm sure that Hester is presented herself and me, so I won't go through that again. This will be part of our introductory session, and Esther, having sort of given you a rough and broad idea of the types of IP and what in fact IP consists of, I'm going to focus simply on introducing the intersection between IP and competition law. And I'll go over Article 101 and Article 102 in broad strokes, and then we will devote more time to each of the articles separately. Let me just get this out of the way here. And move my little cursor. All right, so the first, I'll start with a few general observations and then we'll get into more detail. The first thing that I like to say is that, as Esther in all likelihood already mentioned, because she mentions this at the start every year, is that for the purposes of applying competition law, it is not necessary to define IP under EU competition law. Now that said, there's obviously a few useful definitions that generally find their way into decisions and judgments. I've put here one of the most common from the World Intellectual Property Organization, that intellectual property is essentially creations of the mind, such as inventions that may be covered by patents, literary and artistic works covered by copyright, designs copied by a whole bunch of different forms of IP in different member states, symbols, names, and images used in commerce, such as trademarks, that this IP is protected in law. So it does not exist unless it is protected by law, that this enables people to earn recognition, or importantly, to earn financial benefits from what they have invented or created. So the notion of a reward for the creative endeavor, for the creative effort. The definition also says that by striking the right balance between the interests of innovators and the wider public interest, the IP system aims to foster an environment in which creativity and innovation can flourish. So there's already a balance being struck between, on the one hand, the interests of innovators, who should be rewarded, and the wider public interest in having access to those innovations. Another important observation for what we will then be discussing is that IP is abstract or intangible. It exists as other forms of property so long as, and only so long as, and in as much as it is recognized by law, contrary to, as you know, tangible forms of property, which you can preserve, for instance, by keeping in a safe. Another important observation is that the boundaries of any intellectual property right may be difficult to determine, and often will only be determined once they are legally challenged. And as we shall see, that's, for instance, the case for patents, where it is unclear just by reading, for instance, a granted patent, the claims in a granted patent, where exactly the patent or the claims end, and therefore what the exact boundaries of the right are. IP is also a public good, and it's non-rivalrous in consumption, and it's not excludable. A non-rivalrous means that the fact that I consume some IP does not mean that you cannot consume it also. So if you make use of a patent, nothing prevents me from making use of the same patent. And the fact that it's non-excludable means that I cannot prevent you from making use of the patent except by resorting to the law. I cannot compel you to do so. What are the actual implications from some of these observations? One is that IP can be costly and very time-consuming to produce, and it will require a high degree of inventiveness and originality. But once it is produced, then it's very easy, it's very cheap to reproduce it. It has, in competition law or in microeconomic terms, a very low or zero marginal cost. And this creates what is known as a potential free riding problem. That means that it is easy for others who have not invented to make use of the invention at no cost to them. And that's why we say that it is the protection that is afforded by the IP laws that creates this necessary incentive to invest in the creation of intellectual goods. Absent that protection, essentially anyone could make use of the inventions covered by the IP. And as I pointed out when I was speaking about this WIPO definition of IP, it must be assumed that the different IP law systems in the different jurisdictions have already struck the appropriate balance between, on the one hand, rewarding the creators, and on the other hand, ensuring that the interest of the public is served through the widest dissemination of the creative output. But as we shall see, competition law makes some claims regarding this balance. And how do they manifest themselves? One position that is often stated and which can be viewed as rather simplistic is to say that there's a tension between, on the one hand, intellectual property and on the other hand, competition. Well, why? Again, one of the essential qualities as we've seen of intellectual property rights is that they confer on their owner an exclusive right. So the right to use a patented process, the right to use a trademark, etc., and therefore to exclude others from using or consuming it. And so one could say that IPR, and the term is often used and often in the competition law context misused, it is argued that IP confers a temporary monopoly on its owner. So the right to exclude others, whereas competition law is concerned precisely with the detrimental effects of monopolies, the detrimental effects of the exclusion of others. So why is it that one would say that it is this would be a simplistic analysis, and that one would be wrong to assume that there is a priori a tension between IP and competition law? Well, that's because the monopoly, the temporary monopoly that is the result of IP protection, is different from the monopoly in the antitrust sense. Does anyone know why that is the case? What the difference is? Well, I guess no one wants to venture a guess.
I might, if I may. I just had one idea. If we talk about European competition law as compared to US, for example, it is by itself not against the law to have a monopoly, but just the abuse of that monopoly. So would by itself not be a problem if the patent holder has a monopoly, but rather if he would then abuse it.
That's very true. That's very true. You're absolutely right. It should not be an issue. But my question is more, what is the difference in the monopolies? How do you establish, let's say, a monopoly in the antitrust sense? What does a monopoly mean in the competition law sense of the term. What is it that you have when you have a monopoly?
So monopoly in the antitrust sense is the having 100% of the relevant market.
Yes, that's true. That's exactly it.
In terms of antitrust, it is. I can say that I have a monopoly on the flat I own. So this is, but there are many flats, for example. So this is the basic.
You're right. That's exactly it. So a monopoly in the antitrust sense requires first that we establish what the relevant market is, right? So you need to determine what products are substitutable for each other, and then you determine that there is a relevant market and that he who has 100% of that market will be a monopolist. Now, this is different from the expression, a monopoly, a temporary monopoly conferred by IP. Essentially, what that means is that you can control and you can exclude others entirely from making use of your intellectual property. In the case of a patent, for instance, let's say, a patent over a certain process, you would have to determine, in order for it to be viewed as a monopoly in the antitrust sense, first, that that IP constitute its own relevant market. And we will see, for instance, in the case of standard essential patents, that the Commission, European Commission, has a stake in that view, that one standard essential patent can be its own relevant market, and therefore that he who owns a standard essential patent is a monopolist in a properly defined antitrust market. But in the overwhelming majority of cases, having IP does not over something does not necessarily entail holding a monopoly in the antitrust sense, because the intellectual property will simply form part of a much, much wider relevant market. Let's say a technology market in which many technologies, for instance, compete. So this is a very important distinction to which we will return regularly. Again, going back to the question of whether there is a tension between IP and competition law, the technology transfer guidelines, which are guidelines adopted by the European Commission, very helpful guidelines which explain how the Commission will apply the competition laws to a certain type of agreements relating to the transfer of technology, and we will discuss what that means. These guidelines state very clearly that both IP law and antitrust law in fact share common objectives, and it says that the fact that IP grants exclusive rights of exploitation doesn't imply that IP rights are immune from competition law intervention. Article 101 of the treaty in particular is applicable to agreements where the holder licenses another undertaking to exploit its intellectual property rights. And then it goes on to say, but does this not mean that there is a conflict between IP and the competition law rules? Why? They share the same objectives, promoting consumer welfare and efficient allocation of resources. They both should promote innovation, because innovation is an essential component of the market economy, and that the IP rights promote dynamic competition. And we will return often to this notion of dynamic versus static competition. They encourage dynamic competition by ensuring that companies invest in developing new or improved products and processes and technologies. In the United States, the very useful 1995 guidelines of the FTC and the DOJ on licensing IP essentially establish a principle of symmetry, saying IP should be treated as other forms of abuse and no special principles should apply. So essentially a recognition that competition law and IP should not be at loggerheads. One should not assume a tension between the two fields. The monopolies conferred by IP are different from a monopoly in the competition law sense, and IP should be treated as other forms of property. It is not particularly nefarious. There is no reason to assume that the IP laws are in any way inimical to competition law. So this should be the first principles. And yet, after a long period in which all of this was recognized, assumed to be a truism, IP, modern competition law recognizing the pro-competitive nature of the vast majority of forms of exercise or of exploitation of IP, what we have seen essentially over the last decade, decade and a half, is significant enforcement action by competition law agencies, and a large number of court cases and litigation in which, in particular, and because this is our topic, EU competition law, but this is also true elsewhere, competition law is being used to essentially curb, to prevent many forms of the exercise of intellectual property. So competition law being used to restrict what IPR holders are allowed to do in ways that go beyond, obviously, what is already provided for in the IP laws, and sort of upending this balance that the intellectual property laws would have already struck between the public interest and the need to reward and incentivize creators. So, and this has happened obviously through the attachment of antitrust liability to conduct by the IP owner in relation to its IP. And we will see those manifestations. So how do competition law and IP intersect in the EU? They intersect as a result of the application of Article 101 and also the application of Article 102 to different things. In the case of Article 102, obviously conduct, unilateral conduct by one party, one firm. Article 102, as you all know, prohibits conduct by companies that have market power, substantial market power, and that are therefore deemed to occupy a dominant position. Conduct that can be considered abusive, and this may apply to conduct that consists in exercising IP, doing something with your IP, seeking to prevent someone from using your IP. And we all know what Article 101 prohibits. So not unilateral conduct, but concerted practices, agreements, both between competitors, but also between companies that are not competitors. They're in a non-horizontal relationship or a vertical relationship. So agreements and concerted practices that restrict competition to an appreciable extent. What will Article 101 apply to? Well, it will apply to the terms under which an IPR owner licenses its IP. These are known as licensing terms. And if any of you are wondering what this means, licensing essentially means giving someone certain rights to do certain things, which otherwise they would not be allowed to do under the IP laws. So that's licensing. It's, you know, it's an arrangement that says, I, IP owner, allow you, my co-contractor, to do this and this in relation to my IP. Otherwise, you would not be able to. And so these are The terms under which this happens are known as licensing terms because the type of contract is known as a license. And I'm sure that you are all aware of the different types of provisions that could be. What are the rights? What are the things that I'm allowing you to do with the IP? If it's a patent, you know, what can you produce with the patent? In which regions, what it will apply to, and obviously what the compensation will be. And when you speak about compensation, you mean a price. And in the intellectual property field, the price is generally known as the royalty, although there are other terms, you know, licensing fees, etc. But this is just so that you're familiar with the term royalty or royalties. That's the price that someone will pay for using someone else's IP. Article 101 can also apply to what is generally known as a patent pool or a technology pool, an agreement between several owners of valuable intellectual property to essentially pool together, so combine their IP so that it can be managed and licensed together in combination to third parties. And this is an efficient way in many instances to ensure that certain types of IP, in particular patents relating to standards, where there's many different patent owners and very many patents, can be licensed through a one-stop shop, which reduces transaction costs and is an efficient way. It has its own issues and its own problems. We will see how Article 101 treats those, how it applies. And then finally, Article 101 can also apply, and when we mean apply, it means can also be used to prohibit the terms under which parties will settle their disputes and eventual litigation that relates to intellectual property. And the two articles of the treaty can be applied separately or can be applied in combination, although not frequently, to the same set of facts. And we will see cases in which that also happened. So a few generalities, starting with Article 101 and its application or its applicability to IP and its and the way in which it intersects. So the basic premise is that licensing terms, so the terms, these contractual terms found in license agreements, so licensing terms that restrict competition within the internal market to an appreciable extent, will infringe Article 101.1. Even if that is the case, some types of licensing provisions, they may be exempted automatically under Article 101.3 by virtue of the application, amongst others, of the Technology Transfer Block Exemption Regulation. So the TTBR, as it is known, that's a very useful and very important regulation dealing with the transfer of technology. It's a block exemption regulation, so it exempts from the prohibition of Article 101 certain broad categories of licensing terms that are commonly found in license arrangements. So essentially it says, well, these types of provisions are generally fine, and these other types of provisions can be an issue, or these types of provisions will be an issue in most cases, provided the agreement satisfies a number of conditions. Just as with other block exemption regulations that you will have, I'm sure, already studied, such as the vertical block exemption regulation. It contains some market share thresholds. It says, well, it applies to companies whose market shares are below a certain threshold, so that it does not apply to arrangements between companies that may have substantial market power, but it will apply generally to others. And the TTBR is accompanied by these technology transfer guidelines to which I alluded and which I quoted earlier. And those also provide essentially the framework, and they bind only the Commission, the European Commission, who adopted them. They provide the framework, they specify the framework under which the Commission will examine the application of Article 101 to licensing arrangements for the transfer of technology. So essentially patents and know-how. And the guidelines, although they are binding on the Commission alone, they're not binding on courts, are very influential. They tend to be followed. So most licensing arrangements, they contain restrictions that are been placed by the IPR owner, known in this context as the licensor, on the taker of the license, the licensee, so the company that wants to make use of the IP or who would otherwise infringe the IP. And these restrictions, they will concern many, many different things. So in the case of licenses for the transfer of technology, they will normally concern the quantity of products that can be produced with a licensed technology, the types of use to which a licensed technology, let's say a patent for a process to make something that may be put, the customers to which the licensee may sell. The licensor may say, when you use licensee, my technology, you can only sell to the finished products, the finished goods. You can only sell to customers in France, Belgium, Germany, Portugal, and I reserve to myself the other territories. So that's a type of geographic territorial restriction, which is commonplace, and there are good reasons to do so. Now, the Commission recognizes, and as do most competition agencies and the law, that most licensing arrangements are pro-competitive. In fact, it's not even that they're neutral or that they could be anti-competitive. Most licensing arrangements are pro-competitive. They allow the dissemination of property, of intellectual property, the dissemination of creations in the context of technology and its transfer. They allow the licensor to transfer technology to a licensee who can exploit it. They allow the monetization of the invention, and then they allow for the public good, essentially. Why would there be some kind of conflict? Well, the licensing allows the licensee to engage in an activity that would otherwise be prohibited, barred to it. So it fosters competition. Any restrictions that are placed by the licensor on the use of the IP could therefore be seen as essential if the license is to be concluded at all. In other words, absent the license, the licensee would not be able to do the thing that the license allows it to do. One should conclude, therefore, that if the licensor has the right to not grant a license at all, any restrictions placed in the license should not be an issue. The counterfactual is a world in which there's no license at all. But we'll see that that's not really how things actually occur. An important distinction in this respect is the distinction between intertechnology and intra-technology competition. So intertechnology is between different types of technologies. Intra-technology is going to be competition between the licensor and its licensee, or between several licensees with regard to the technology covered by IP that is being licensed. So going back to this this issue of why should one be concerned with restrictions that essentially are placed on what the licensee or several licensees can do with the technology in circumstances where, absent the license, there might be no competition. Well, Article 101 has been applied to this type of provision mostly because Article 101 has been used to address what is known as the single market imperative. So this need to create a single market within the EU, Article 101 has been used to ensure that there are no exclusive territories allocated to different parties, and this would mean different territories allocated to licensees. So in particular, where these provisions result in this type of geographic protection, Article 101 has been used to prohibit them, which is obviously something questionable from the standpoint of the sound application of competition law. Competition law should be unconcerned with the creation of a single market. That's for a different type of law and for a different field. So what are the common types of licensing provisions or of licensing restrictions that are to be found in nature? And I'll go through a number of them to give you an idea. We can find territorial exclusivity. What does that mean? That means that the provision concerns the territories in which the technology can be exploited. Often the licensor, meaning the IP owner, will reserve a certain territory to itself. Again, this is of crucial importance because of the single market imperative. It will say, I'm granting you a license to use my patent to manufacture these water bottles, but you can only sell them in Portugal, Spain, and Greece, and I, licensor, retain the rights to sell them, elsewhere. So this is a type of territorial protection, the grant of exclusive territories for the exploitation of the IP. The mere grant of territorial exclusivity doesn't infringe Article 101. We will have generally an infringement where absolute territorial protection is provided for in the license. So it's where the licensing provisions essentially stipulate that no parallel imports of the goods are going to be permitted, and we will see a distinction between active and passive sales by the licensees. Another type of common licensing restriction found in license arrangements will consist in field of use restrictions, and that's essentially where the licensor says this technology can be used for very many things, but through this contract, I'm only granting the right to use it for this purpose. So if you have a technology that allows you to manufacture many different types of chemical products, a field of use restriction would specify that the licensee is allowed to manufacture only one such type of chemical product. These are generally unproblematic. Then we have non-compete provisions. As the name indicates, that means that the licensor, that the licensee, in this case, commits not to use third-party technologies which would compete with the licensed technology. Why would that be in the interest of the licensor? Well, the licensor may have a very strong interest in ensuring that the licensee to whom it is granting these rights has sufficient incentives to invest in the exploitation of the licensed technology. So there are good, sound, pro-competitive reasons to have a non-compete provision. However, this may be an issue where it results in the foreclosure of suppliers of rival technologies. And we will see that, therefore, this may constitute a prohibited restriction in certain circumstances, requiring, obviously, as with all of these, a fact-specific assessment. We also find typically in license arrangements provisions that relate to payment, so royalty provisions. How is the licensee going to remunerate the patent or the IP owner for this transfer of rights? And you'll find many different types of terms that relate to payment. You can find running royalties, meaning that the licensee will pay a certain price that is calculated on the basis of the volume of products produced, sold every year, and hence the name running. Throughout the duration of the arrangement provides that these payments will be made. You can have upfront payments, meaning that the licensee will make a payment, often sizable payment, upfront, the moment it concludes the arrangement. You could have royalty obligations post expiration of the licensed IP. So the agreement could say that even after all of the IP that is being licensed has expired, still the licensee may need to pay a royalty once it manufactures goods which in the past would have infringed on that IP. The provisions relating to the royalty payments are generally not an issue under Article 101, but there may be certain circumstances, and there's in particular one case to which we will turn later, Genentech, that deals with this notion of post-expiration royalties. And we will see when we turn to Article 102 that issues relating to the payment and the level of royalties may become a problem under Article 102. Then we have provisions relating to the pricing of the licensing goods. These could be licensing provisions that say that the licensee will not sell products that make use of the technology being licensed below a certain minimum, or that they must sell them at a certain price. These are generally not will generally be an issue if they impose minimum or fixed prices for the products that will be sold and produced on the basis of the licensed technology. We will often find quality requirements in licensing terms. That means that the licensor obliges the licensee to ensure minimum quality of the product that is made with the licensed IP. It could, for instance, provide that the licensee, when it makes those products, must use other inputs of a certain type. It could even say that the licensee must buy those other certain inputs from the licensor itself. These are generally not a problem if they are justified by the need to ensure that certain standards applied by the licensor are to be met, and where it is based on objectively verifiable criteria. In other words, that they are not created just at the whim of the licensor. There's criteria justifying objectively the quality requirements. One can also find minimum quantity requirements. The licensee commits to producing a minimum volume of X products with the technology via license. And you'll also find provisions on duration. The arrangement, this arrangement will be valid for 5 years, or it will be valid forever. These are generally not a problem. Other types of provisions with which one will need to familiarize oneself: no challenge and termination clauses. What are these? Well, no challenge, as the name suggests, means that in the licensing arrangement, the licensor says, you licensee, well, you will not challenge the validity of the IP that I am hereby licensing you under. Why? You've heard from Esther of such a thing as the validity of the IP, right? So in the case of patents, the patents are granted, right, by patent agencies, and if they satisfy certain requirements, there is a presumption that they are valid, but they can be invalidated, just as a trademark can be invalidated, although it is registered. Who would be the person best placed to realize that a certain type of intellectual property right, even if granted, even if registered, in fact doesn't satisfy the requirements to be a valid form of IP? Well, presumably it would be a licensee, so a person who would be exploiting it, who would make use of it. And in many cases, licensees would even have an incentive after they've entered into an arrangement to turn around to the licensor and say, well, we don't think we owe you anything because in fact this IP is not valid. There's ways to challenge validity before the agency, the state organism that granted it, but you can also challenge before a court of law in different circumstances and with different effects. The no challenge clause means that the licensee will not challenge the validity. A provision that says that the licensee can challenge, but if it does that the license will be terminated, that's known as a termination upon challenge clause. So two types of clauses, both relating to what happens if the licensee seeks to challenge the validity of the IP, and the guidelines, the technology transfer guidelines currently in force, they suggest that although in most cases these are not an issue under Article 101, they don't restrict competition, they may be an issue under certain specific circumstances requiring a factual assessment, where the licensed IP is valuable, and in particular, if the license concerns patents that are essential to an industry standard known as standard essential patents. And we will see in more detail when we deal with standardization, the circumstances in which this could be a problem. So no challenge and termination clauses, they are also commonplace in license arrangements. We have other types of provisions relating to tying and bundling, and that's an obligation on the licensee to actually buy certain things from the licensor, or sometimes to take another license for another technology as a condition for the conclusion of the license. Again, as with other types of requirements, quality requirements, for instance, this will not be an issue as where the obligation on the licensee is necessary to ensure that the licensed technology is exploited properly. The typical example is for a license for a certain packaging process, as we found in a number of cases, including, you know, Tetra Pak, that the licensee commits that when it uses this packaging technology to make cardboard containers, that it would buy a certain type of paper from the licensor. It's not an issue, as I pointed out, when the TAI is required to ensure that these minimum objectively verifiable quality standards for the licensed products need to be met. It can be an issue, as we shall see, where the licensor has significant market power in the tying product, and the obligation covers a large part of the tied product because it could foreclose rival suppliers of the tied product. So having gone through, okay, before I turn to the potential effects, so we've gone over types of licensing provisions that you will find often in licensing arrangements. Mostly these are the ones that relate to the transfer of technology. Are there any questions? Is anything unclear? These are just examples of clauses, contractual clauses, provisions that one will find in such arrangements. It's a broad overview. Is anything unclear regarding the terminology or something that I might have said?
Professor?
Yeah.
I have a question.
Yeah.
Because I have read some case they will the licensor will insert conditions in the license agreement that the licensee also need to license a certain patent to the licensor. Is this kind of provision is problematic or is okay?
Well, typically that's not a problem, right? That's what you mean, I think, is a cross license, right? Which is yeah. So the licensor, in return for the license grant from the licensor, the licensee also grants in turn some rights to some other technology. Yes, that's a cross license. Invariably, cross licenses are not a problem. We will also see the circumstances in which a cross license might be an issue.
Even though that is for free, if the cross license is for free, then also no problem?
Well, it depends what is meant by for free. The fact that the license doesn't specify that there is a certain license fee or royalty associated with the transfer of the licensee's IP, that doesn't necessarily mean that the license grant, the cross license, is not valued, right? It can be valued and be reflected in the other part of the royalty that the licensee has to pay to the licensor, right? It can be viewed as a reduction in the price that the licensee has to pay the licensor. So this would be a case in which, although there is no pecuniary value that is identified, right? An amount that is identified specifically, it's still valued. And even in circumstances where one might say that the cross-licensed IP is not being valued by the licensor, that would not necessarily be a problem either. And we shall see, you know, circumstances in which, in fact, cross-licensing is the norm when you're licensing, especially when the license the rights being licensed by the licensee are in the same field, in order to ensure that both parties enjoy freedom to operate. It would be obviously quite absurd for a licensor to grant rights to a certain party only then to be under the threat that that party would prevent the licensor itself from making products because they would infringe on the licensee's IP. So cross-licensing is very common, and in the overwhelming majority of issues, cross-licensing is not an issue. We may have issues perhaps when, for instance, there's a tie and the license, as we will have seen, there are issues of market power.
Okay, thank you.
All right, so I wonder, we've been quite slow, but I need to sip some water, and I do realize that it's already 5:20 and that people may be falling asleep unless they take a short break. So let's have maybe a 5 or 10 minute break, and then I will continue, and I guess we can meet here in 5 to 10 minutes.
Perfect. Thank you, Miguel. Miguel, do you want to start again?
Okay.
It's up to you.
Yeah, let's resume.
Yeah.
All right. So I will now turn to the potential anti-competitive effects of these licensing terms. Where was I? Here. So, as I mentioned, the most common type of restrictive effect on competition is going to be a reduction of inter-technology competition. So, reduction in competition between technologies that are not owned by the same party. Technologies that compete with each other. As I said, this is different from a reduction in intra-technology competition. And how would this, with these restrictions, what type of restrictions are we talking about? Well, first we can have, as a result of licensing arrangements, a restriction of competition in innovation. How would this occur? Well, competitors would enter into arrangements whereby they transfer competing technologies to each other. They would impose obligations to provide each other with future improvements. This might prevent either competitor from gaining a technological lead over the other competitor. So this would be an arrangement whereby two rivals have technologies, they enter into cross licenses, and then there's a reduction in the incentives for either of them to compete with each other in the field of innovation. They would innovate less. They're already licensed. They don't fear being overtaken by the other. So that's the negative impact on innovation. We can also have, as a result of a licensing arrangement, a reduction in technological competition as a result of collusion. That's sort of the garden variety type of anti-competitive practice. The agreement between rivals that will facilitate collusion by the rivals. A risk that is higher in concentrated markets. And third, we can have a risk of foreclosure of suppliers of technologies that are substitutable because the license arrangement results in the creation of barriers to entry. The agreement would prevent the licensee from obtaining licenses from third parties. We saw the non-compete obligation that you would find in the license arrangement, and there's many good reasons why you would have a non-compete obligation, but it could result in there being an insufficient number of licensees that are available to third parties in circumstances where entry at the licensee level is difficult. So what are we talking about here? Well, it just means that there's a limited number of potential licensees and a limited number of companies that could use a technology, and then you have a number of licensing arrangements that essentially prevent the licensee from exploiting other technologies. There's a non-compete obligation. The arrangement says you licensee can only use my technology. Well, it may be the case, although this is obviously infrequent, there may be the case that because a few of these licensing arrangements exist and they all have non-compete obligations, that one company that has technology which it wishes to have exploited by others, they will not be able to find a licensee The few companies that could exploit the technology, they have already entered into license arrangements that say you will not use someone else's technology. So that would be a reduction in inter-technology competition as a result of the foreclosure of a supplier of technology. Another example of this would be a case in which the licensor has a significant market power, and it ties together various parts of the technology and then licenses them as a package. But only one portion of the package is essential to produce a certain good. What does this mean? That means that there's a tie between the different technologies in our example, and the licensees need to obtain one of the essential technologies, but because they're only the technology that they need, this input is only available as a package, they're also paying for other technologies, which they would not necessarily want to obtain from this particular technology holder. But because they want the essential technology in there, that means that then, because they've paid for the package, they're going to be precluded or disincentivized from essentially licensing those bits which they would rather buy from someone else, license from someone else. They'll be disincentivized from going to these other technology holders to obtain a license. Again, these are things that are infrequent. Licensing arrangements can also produce negative restrictive effects through the reduction of intra-technology competition. So competition between the companies that actually supply products that are manufactured on the basis of the same technology. We've seen that this is going to be the case where there's territorial restrictions on the licensees, which means that they cannot sell into the territory of another licensee, and there will be less competition between them. This is, strictly speaking, as I mentioned, not really a competition law problem so much as an issue related to the desire to create an EU-wide single market. And it's obviously much, much less of a concern. And I will now turn to and I will go, quickly through the remaining, maybe 10 slides or so. As I mentioned, how does one analyze these potential restrictions under Article 101? I've told you that there's these very useful technology transfer guidelines from the Commission. They set out a clear framework. And there's the accompanying block exemption regulation, or perhaps it's the other way around. Block exemption regulation and accompanying guidelines. As I said, the block exemption regulation on technology transfer provides block exempts under Article 101.3 certain types of provisions commonly found. What does it apply to? Well, it applies to technology transfer agreements. That means a patent licensing agreement, an agreement providing for the transfer of know-how, software copyright licensing agreement, or a mixed patent know-how or software copyright licensing arrangement. The agreement for the technology transfer block exemption regulation to apply, the subject matter of the license has to be this. It is not going to apply to agreements that deal with trademarks. It has to be a bilateral arrangement, so not multilateral. Two parties, licensor and licensee. It has to be a license arrangement between these two parties to transfer this type of technology for the production of certain goods. So it's not for the distribution of the products. It's an agreement that says the licensee will produce goods on the basis of the IP, so the know-how, the patents or the software being conveyed. These are the essential requirements. The TTBR provides for market share thresholds. It says it will apply as long as licensor, licensee market share is below a certain level. And here, an important distinction between technology and product market. The technology market is the relevant market that includes all substitutable technologies. And then downstream from the technology market, you have the product market. And that's the market in which products compete with each other that are based on the technologies in the technology market, but not necessarily so. The TTBR provides, as I said, for hardcore restrictions that are non-exemptable. So it says there are certain categories of licensing restrictions which, if they are to be found in a license arrangement, will mean that the exemption ceases to apply to the entire agreement. You can think of the hardcore restrictions as black provisions. These concern, for instance, the cardinal sin of competition law, the fixing of prices. It will also apply generally to provisions that grant absolute territorial protection on the licensees. So that's for the TTBR. Now, the TTBR says, if this agreement satisfies these criteria, market shares, it's for these things, it doesn't contain these provisions, etc., etc. We know that the block exemption applies, and therefore the agreement is, as a matter of fact, as a matter of course, exempted under Article 101(3), meaning it cannot be prohibited. But what happens if the agreement in question, an agreement for the transfer of technology, doesn't satisfy all of these criteria? Well, there is no presumption that the agreement is an anti-competitive agreement. There's no presumption that it will even fall under the prohibition of Article 101(1). All it means is that one has to engage in a self-assessment, meaning that you have to examine the effects of the agreement in practice. It's a factual, specific examination. This can be the framework for this analysis is found in the technology transfer guidelines. They set this legal framework under which the Commission assesses whether the agreement could result in a breach of Article 101. So what does this mean? That an agreement, that a self-assessment has to be undertaken, and that the licensing arrangement has to be examined. Well, that means that the agreement must be considered in its totality. So by reference to the entire factual, legal, and the economic context in which the arrangement was concluded. Just as any other agreement, any agreement that does not relate to intellectual property. It's the same type of analysis with some specificities, with certain common elements that are generally found in licensing arrangements, and which we know from experience should or should not result in restrictions of competition. So when you look at the agreement as a whole, the usual factors are taken into account in the assessment. What is the position of the licensor and the position of the licensee in the technology market and in the product market? What are their market shares? First, obviously, you start by defining what the relevant technology market is. What are the different substitutes for the technology being licensed? What are the market shares? Are there many technologies? Are there few technologies? Then you look at the product market, the downstream market for the products that make use of the technology. Is the licensee a large supplier? Is it a small supplier? Then you look at the nature of the agreement. What does it provide for? What are the competitors in the technology market and in the downstream product market? Who are the buyers? Are there barriers to entry? How easy is it for a licensee to enter a market to produce the goods? How easy is it for a licensor, a potential company to develop a rival technology? Are there many potential entrants? Maybe companies that are not licensing their technology, but they're licensing similar technologies that are not true substitutes, but which could become substitutes following some small investment. So these are the usual elements that one would rely on to examine the competitive impact of an agreement under Article 101. The TTBR guidelines do tell us that in the case of this individual self-assessment, it is unlikely that the hardcore restrictions of competition that are listed in the block exemption regulation would fulfill the conditions of Article 101(3). Not impossible, but unlikely. So if one finds these restrictions, it's unlikely. Care will have to be taken to ensure that they are properly examined and that one would have good reason to believe that they would not result in restrictions of competition. The guidelines provide for a very useful and important safe harbor. The guidelines say that when the Commission is examining whether a certain license arrangement could result in a restriction of competition, if there are 4 or more independently controlled technologies, so a minimum of 4 technologies in addition to the technologies that are being licensed that may be substitutable, it's highly unlikely that the license arrangement would result in an impermissible restriction of competition. So this is a very useful safe harbor, especially when one is examining in private practice an agreement, a license arrangement being contemplated by one's client. If it is possible to determine that in addition to the technology that forms a subject matter of the license arrangement being contemplated, there are at least 4 other substitutable technologies, well, we know that it is highly unlikely that the agreement is going to breach Article 101. So, what is the mechanism that one uses, the intellectual process to determine the likelihood that an agreement would breach Article 101? And that is the mechanism of the counterfactual. What would occur in the absence of the agreement with its alleged restrictions? What if the agreement is not concluded? What would happen? And then the assessment will be based on 2 questions, one relating to intertechnology competition, the other relating to intertechnology competition, all set out in the guidelines. The first question is, does the license agreement restrict actual or potential competition that would have existed without the agreement? So if the conclusion is, if we don't enter into this agreement, had this agreement not been entered into, what would be the state of competition? And then the same question essentially is applied to inter-technology competition. So this very useful analytical framework is undoubtedly progress. It has called into question the usefulness and the validity of some Commission decisions that were adopted in the years that preceded the adoption of the guidelines and the block exemption regulation, as well as most of the case law of the Court of Justice on licensing. Although we do have one issue, which is that since Regulation 1, the enforcement regulation, right? The regulation under which the European Commission enforces Articles 101 and 102, since it was adopted in 2003, the Commission since then has not lost, but since Regulation 1 of 2003 has been enforced, in order for parties to benefit from the Article 101(3) exemption, they no longer have to notify these arrangements to the Commission. So previously, under Regulation 1762, the way things worked were only the Commission could exempt under Article 101(3) an agreement that would otherwise restrict competition and under Article 101(1). Since the modernization package was known as the modernization package came into force with Regulation 1 2003, that is no longer the case. Companies can enter into arrangements that would otherwise infringe Article 101(1) if they are satisfied that it would be exempted under Article 101(3). Notification to the Commission is no longer a requirement. One of the effects, one of the consequences of this modernization of competition law has been that the Commission no longer receives arrangements, is no longer there, it's no longer notified, and therefore it no longer examines a large number of such licensing arrangements, which then are exempted or prohibited by a decision. And so there's been a dearth of decisions applying Article 101 to license arrangements, and very few court cases also, and that makes it harder to know how nowadays Article 101 is being applied, how the technology transfer guidelines and the block exemption regulation is being applied in practice. And within the remaining time, maybe 10 minutes, I will briefly talk about, so I said that Article 101 would apply to licensing arrangements, Article 101 would apply to technology pools, and Article 101 would apply to the terms under which disputes or settlements relating to IP. The terms under which disputes and litigation are settled. What are turning now to the technology pools? As I said, it is not uncommon for two or several companies to bring together their technologies and form a technology pool. And that's essentially an agreement to manage and license a package or a bundle of IP that is considered to be pooled together. As I said, this can be very efficient. It can be very useful. These technology pools will contain technologies covered by intellectual property rights. They can be simple, they can be very informal, or they can be very formal and very complex. Often they're found in fields relating to industry standards. So for instance, there's a number of technology pools that support the licensing of technologies that are essential to mobile communications, technologies that are essential to in the past DVDs, to motion picture compression codecs, any number. These products, mobile communications, for instance, as you all know, are standardized. We'll have a session devoted to the issues relating to standardization itself. When these licensors, these technology holders decide to form a pool, they will enter into an agreement. Essentially, the agreement says, okay, we form this pool for these purposes. The pool will if it's a complex pool, the pool will have so-and-so as its manager. It will cover technologies owned by companies A, B, C, D. It will be based here. There's provisions on financing bylaws, etc. That's the pool agreement. The TTBR will not apply to this agreement. It will apply, by contrast, to the individual licenses that are granted by the pool. So the pool is constituted to license the technologies of the different technology owners through individual licenses, and the TTBR will apply to these licenses. There's two ways in which the technology pools may restrict competition. One, the first, if the pool technologies are substitutes, their licensing, meaning their joint selling through the pool, would amount to price fixing. Secondly, if the pool technologies are complements, but they're not essential to produce a certain product, there's a risk that you could foreclose third-party technologies. This is similar to what I had mentioned earlier about a licensor who licenses its technologies as a package, where the licensee, in fact, only wants one technology. It's an essential input, but because they're only licensed as a package, it also has to pay for these other technologies that it did not desire. And because it has done so already, of course, it will have no incentive to pay twice to some other licensor who has some other substitute technology, which the licensee might prefer. So these are the two manners in which licensing pools can restrict competition. And finally, Article 101 can be applied to the terms under which parties settle disputes relating to IPR as a result of the application of Article 101. These arrangements may be found to be anti-competitive. The guidelines recognize that settlement agreements in the context of technology disputes are, in principle, a legitimate way to find a mutually acceptable compromise to an actual bona fide legal disagreements. There's all sorts of reasons why legitimate, justifiable reasons why parties would want to settle, why this is efficient, why they would put an end to their dispute. And that means that in most cases, the terms under which the parties have settled a dispute relating to IP are generally not suspect. However, there may be circumstances under which they could be a problem. And the most glaring example of such settlement arrangements that could restrict competition is to be found in the abundant case law and decisions relating to pay for delay. I'm sure that you've all heard about pay for delay case. For a long time, antitrust agencies had expressed concerns over the terms under which originators, so pharmaceutical companies that have, patented a drug, settle patent disputes with makers of generic drugs. So drugs that are no longer that are not actually, it's getting a bit late. With generic drugs that do not benefit from patent protection because the patents for the original molecule have expired, and so the concern has been that once this patented molecule or substance or process is nearing its expiration, the patents will expire. They've reached their end. The originator, meaning the drug company that patented it or who is the owner of the IP, would seek an agreement with the maker of these generic drugs, not to enter the market for the pharmaceutical product in question. Usually, this would be done by means of a large payment. In other words, the maker of the original drug would pay for delay, so that the generic producer delays its entrance into the market. These have been found to be an issue in several cases, and the condition that have to be satisfied for this to be a problem are going to be discussed in more detail by Esther in a session devoted to pay for delay settlements. For now, suffice it to know that problems are likely to arise in circumstances where the settlement arrangement provides for a significant transfer of value from the licensor to the licensee. Those are the circumstances in which this could be an issue, and this will be dealt with in detail in subsequent lectures. So that's for Article 101. I've run through it perhaps more quickly than I traditionally do, but time was of the essence today. That's for the application of Article 101 to the exercise of IP, focusing on technology transfer and the guidelines. The other way in which antitrust or competition law intersects with IP is through the application of Article 102. So a few brief observations. We will deal with both Article 101 and Article 102 in more detail in the next lectures. This was just the introduction. So Article 101 and 102 prohibits unilateral conduct, so the abuse of a dominant position. Article 101, it applies to concerted practices or arrangements between two or more companies. Article 102 to the conduct of one company. A few observations, thoughts that are particularly important for its application to intellectual property. The first is that the mere ownership of IP cannot be challenged under Article 102. It is, however, the exercise of the IP that may be found abusive. Also, there's no presumption, as I said at the beginning of the lecture, that intellectual property confers market power on its owner. No presumption that IP results in a monopoly in the competition law sense of the word. One needs to look at the entire legal, factual, and economic context. One needs to determine relevant markets before one can reach a conclusion on the existence of market power. As I also mentioned when we started, the application of Article 102 to prohibit conduct that relates to intellectual property was rather exceptional. Nowadays, it is much more commonplace. The seminal case on the application of Article 102 is a court ruling in a case from 1988, and then a few more important cases adopted in more recent years, starting with Samsung and Motorola, which two cases that created much controversy and which resulted in the handing down by the Court of Justice of a seminal ruling on concerning standard essential patents. So over the last decade, a very significant increase in the number of cases in which competition agencies have gone after conduct that relates to IP. Many possible, many reasons have been put forward to try to explain why that would be the case. Why would it be necessary now to enlist competition law to seek to curb the exercise of IP, and why that would be a good or a bad thing? Reasons such as alleged deficiencies in the patent system, or efforts by market actors to devalue IP, problems relating to increased strategic patenting by companies, but we will discuss those in more detail. What are these possible abuses of a dominant position? The most commonplace and the one that has really resulted in the most important judgments setting out the relationship between Article 102 and intellectual property are refusals to grant licenses, and starting with the car parts cases and leading all the way to McGill, IMS Health, more recently Microsoft. Another type of abuse, a potential abuse that has been handled both by competition agencies and courts, excessive royalties. So essentially the excessive pricing prohibition of Article 102 applied to the price paid for a license for intellectual property. But we also have more uncommon types of conduct relating to IP that have been found to be abusive. At the end, obviously, this pay for delay, prevent or delay the entry into the market of generic drugs that compete with patented molecules, discriminatory licensing fees that breach Article 102D, conduct relating to standard essential patents in respect of which a friend commitment has been given, has also been found to be potentially an abuse of a dominant position. Different types of licensing restrictions that have resulted in barriers to the entry of rivals. There's at least 2 decisions by the Commission in which that's the theory of harm. the abuse of the patent system and misrepresentations to patent authorities by a drug company. Well, that was found to be an abuse of a dominant position in the AstraZeneca case. And finally, patent ambush, a somehow questionable type of conduct in relation to which there isn't much clarity, but which the Commission has taken the view, although this has never been confirmed by any court, the Commission has taken the view that it could constitute an abuse of a dominant position, and the unlawful acquisition of a company, a line of case law which may no longer be particularly relevant today, but which I have seen raised in more recent times with regard to the acquisition of an exclusive license. So these are the types of abuses of a dominant position that we will cover in more detail. We will devote some time to the special case of standardization, because it is so important that it is covered by a specific chapter in the Commission's non-horizontal cooperation guidelines. As you know, standardization means creating standards, technical standards that allow mostly products to interact. It's a fundamentally pro-competitive activity. It is essential to the success of many industries, and in many such industries, it requires use of many different types of technologies covered by abundant IP. We will see how these agreements that relate to standardization may breach Article 101, the specific rules that could apply, and also how the standardization, conduct relating to standard essential patents could constitute an abuse of a dominant position. And I think time is up, so I'm happy to answer any questions, but just bear in mind that these issues will be covered. This was an introduction to give you an idea, a broad picture of the ways in which competition law intersects with IP, and then they will be covered in more detail in our two subsequent lectures. But if there are already any questions, anything that could be unclear, I'm also happy to answer.
Thank you very much, Miguel, for this introduction. I'm not sure. Is there any question for the moment? I'm sure there will be next week then, if you have the time to read through everything that we've seen today, and then come back to us with a few questions for Esther and Miguel. Thank you.
Maybe I would like to also ask all the participants for next week. We will have a little bit of homework, nothing really very excessive, but a little bit of preparation so we can look together also at a licensing agreement. And Miguel touched upon the patent pools. We also will have an example of a third-party license related to a patent. So it would be nice if you had even when it's just a quick look, if you do that in advance, and then we can go through it more easily. So that would be nice.
Perfect. Thank you. Thank you very much. Okay. So I will send an email about that also to the students on Monday. Okay. Thank you very much. I wish you all a good weekend.
Thank you all. Bye-bye.
Thank you. See you on Friday. Bye.
Thank you, Valerie.
Thank you.
Bye-bye.